Is allowed.
Number 2,
Memo file. It has been published. Memo file for service of notice through publication to respondent is accepted. The respondent is deemed to have been served. Appeal is admitted for hearing. Huh? Let record is there. What is the record? Not yet admitted. Okay. Admitted for hearing. Office is directed to secure the record.
number 3, the SS Purnima, 387.
My lord, I appear for respondent number 7 in this case, my lord, serial number 3.
I appear for the appellant in serial number 3, Your Lordship.
Yes. Yes. Two of 22. Two of 22.
So, see, in the month of to me, bankers. There was a law
No. So what happens in case we succeed in appeal? Supposing if the appellant succeeds in appeal, we don't know. We will hear. If appellant succeeds, we don't know what happens if the appellant succeeds in appeal.
Yeah, no person pay the
Beneficiaries in appeal. They are the, if he gives 50% guarantee, then we can. Land clearing can be done, or at least.
So we will permit you to withdraw 50% subject to furnishing personal security, right?
I have a submission to be made.
Fine. 50% subject to furnishing personal security. Yes, madam, you are beneficiary, right?
Your Lordship, I have a submission to be made is that respondent number 3, the City Municipal Councillor, CCRA, in whose favor the ownership needs to be transferred is not yet executed as per the DC orders. Lord, without
that is between you. That is between you and the government.
So, supposing if he doesn't transfer it for another 99 years, the owner should not get the compensation, right? He should run around and die.
Your Lordship, my humble submission is that keeping in mind
So
that
we thought that you will make a submission with regard to disbursement of the amount.
yes, my Lord, yes, my Lord, I'm coming to that.
Madam, we are inclined to permit him to withdraw 50% subject to furnishing personal security, not bank guarantee. Where from he has lost his land, where from he will get the guarantee? If he has lost his property, he is not getting any compensation. How he will survive? And
Please,
you have been reimbursed by the government, right?
Yes, Your Lordship, I've been reimbursed from the state finance.
So, Mr. What do you say? 50%, no? Correct.
Lord, the percentage may be determined based on the fact that the ownership is not yet transferred in favor of the government. That is my only submission, Your Lordship.
Ownership means he is the owner, right? The respondent who has filed an
Indeed, Your
application.
Indeed, Your Lordship. He is
If
the
it is
owner.
not transferred for XYZ reason, how you return his property then? Return.
Without deposit, how you
Yeah,
calculate
I mean,
acquisition?
you don't want to pay him compensation. Hand over the possession to him in case you are unable to get the this thing land transferred in whose favor, whosoever's favor. Return the land to him. Why he should suffer? You are not disputing that he is the owner.
I bow down to your lordship.
How can this be, madam? Heard on IA 2 of 2022. Learned counsel for the appellant. We have heard learned counsel for the parties at length. Learned counsel for the appellant has not disputed the fact that which respondent? Respondent number 6 is the owner of land in question. It is also not in dispute that an amount of rupees 2 crores 88 lakhs 93,070 has been deposited by the appellant in the registry of this court. And the aforesaid amount has been paid to the appellant by the state government. Paragraph. In view of the fact that respondent number 6 is the owner of the land, we are inclined to we permit him to withdraw 50% of the amount deposited by the appellant, subject to furnishing personal security. The amount shall be disbursed to respondent number 6, subject to proper identification. Accordingly, IA 2 of 22 is disposed of.
Rival claims related compensation.
My lord, I appeal for respondent number 7 in this. I have a submission to make, my lord. My lord, we have
You are
filed an
not
IA
saying-
number 2 of 21 for recalling the order dated 13/11/2019, my lord. That has not been put up, my lord. The submission in this regard has been made.
That IA number, which IA?
IA number 2 of 21, my lord.
2 of 21 be listed for consideration.
Please, my lord.
Oblige your lordship.
Dismissal of the appeal. There is a preliminary order now. We will have to deposit the amount, file an application for restoration. Preliminary order in view of preliminary order dated 30th/11/2022, the appeal stand dismissed.
Pradeep Kumar.
Memo has been accepted.
Memo was, I think service on the council appearing for.
Memo is taken on, right? Memo is taken on record. Let the orders are next. The memo, the same is taken on record. Let the appeal be listed for order. It should come up next week.
For the petitioner, my lords. Lords, we have served the learned counsel, Mr. Ariga, but I'm instructed that he has, my lords, informed my advocate on record that he would not be appearing in this matter for R5 and 6. My friend could kindly use the mic, my lords.
Take my, at least speak into the mic.
Grateful.
Now that I have inspection to appear, I would like to find objections. to
Oh, he has instructions to appear.
this. Now,
Very
yes,
well, my lords.
Time.
they have to come to mediation. For this reason, there is no illegal detention. They have filed a petition before the UK High Court. And in the UK High Court, there is a therefore, I will read it out
State order against whom?
against the mother, that is the wife and 2 children. According to
What instant order?
because the also this
No, please tell us, sir.
the order reads that respondent so and so and any other person served with this order each hand over to the fifth staff as many of the following documents as are in his or her possession or control, every passport relating to the children of Manisha Padekal and Nainika Padekal, including an adult passport of which the children Manisha Padekal and Naina Padekal and travel and every identity. All documents are seized by the British police. And there is also a restraint order. There are
File statement of objection, right? How much time?
2 weeks time it will be granted after vacation.
So your lordship, will kindly give us liberty to move the vacation court notes once the objections are filed.
Yes.
Please.
Grant them the liberty. We are granting you 2 weeks time. You manage, Mr. Vijay. We can't handle the case beyond this point, right? He has to be granted liberty. We are granting you 2 weeks time. Learned counsel for respondent number 5 and 6. Grace warrant is granted 2 weeks time to enable him to file objections like it. Learned senior counsel for the petition. Learned counsel for senior counsel for the petition is granted the liberty to move the matter during the summer vacations of this court.
Obliged.
Yes, Mr. Please ask, please supply him a copy of the petition. That's what it's saying. Your colleague would do it probably. Yes.
Great.
7 objections.
Now, both of the day. Problem urgency is the documents are granted in custody.
Minor child.
They need to succeed.
Ah.
They tried execution.
SLP dismissed.
Then they protect her till the 15th of March. Then she moved a memo saying that to recall the order of dismissing exemption. Day before yesterday, that also has been closed. Not the documents she had made a submission for this court. The child was studying with new organs. We went there, no child that made study or is studying. They be removed or they have removed.
Current senior counsel for the petitioner. At her name undertakes to comply with office objections during the course of the day. Notice on behalf of respondent 1. You take instructions, Mr. There is already an order in his favor. There is already an order in his favor, and the order has been passed by division bench of this court, has been upheld by Supreme Court. Despite that, I mean, this is really trying to hoodwink the process of the court. Please see. You have to take special care to ensure well-being of the child also. That we are telling you. He is in danger, he or she may be in danger, we don't. Notice, all right.
That was said by the Honorable Supreme Court. Every time she moved a memo, letter saying that I want 4 weeks as the parallel procedure. But I have to argue that execution event. First time he refused, saying that some discrepancy in the address. Second time he went to our office.
No, it's that case. She may say that I'm suffering from corona. That case, right?
She already said.
No, the lighter way, Mr. We are not listening. I mean, because we are under tremendous pressure because of live streaming, right? We are very conscious of the fact, but we can't say anything we don't want to. Yes. And we only said because you have to take care. Please take care. 1 and 2, not an ordinary case that dispute between petitioner and R3. We have no role to play. No relief has been sought against us. Good. It has a background. Except notice on behalf of 1 and 2. Office is directed to reflect his name. Issue emergent notice to respondent number 3. You will be able to do it. In addition, learned senior counsel for the write her name. Learned counsel shall is at liberty to take out hand summons for service of notice on respondent.
Why don't you serve it? Because we don't, we are very worried about.
This form. This form 19th April 20. Yes, what is the prescription?
Deputy respondent, National Medical Council. He'll have to make a representative to National Medical.
Notice has been issued. Not yet.
Last date, we have been the complaint. And the report has been done about.
Yeah. Yes.
Yeah, third also.
Colleges will not upload it. Initially, my lord, they find it before the letter, still there, my lord, thereafter. When we pointed out the matter. But we,
But learned single judge has already issued notice. So that's why he is not arguing. Not even telling. What is his case? You tell us.
the college is not uploaded. His admission to the National Medical Council.
So who appears for the college? Huh? As if whether college served.
College has to upload the admission to the National Medical Council.
College is not appealing. How it has been served? And what about relief 3 medical council committee? Admitted? What is that?
We have got nothing to do with that. But we can propose it that the National Medical Council has to do.
Who appears for medical counseling committee? You are appearing. So there is a direction against. You are not concerned.
The NSC.
Who appears for NMC? Name is not shown.
Who they have included in.
Pleaded
Right now.
It is allowed. Notice has been issued. No. That's the problem. No, you don't tell us any, why it is listed today. Why the,
No, including allow again.
why
It's allowed.
means. I'm showing the cause. It's our duty to show it.
Sir, there are office objections on the impleading application, whether you have complied that,
Copy not, sir.
or we have to do it.
I'm filing a FIA for impleading.
Yes.
Rectification of office
Office objections. Copies not served.
copy not served, and you are telling us that they should be, my name should be uploaded. That you are not telling, he is telling. They have not been served. They have been served.
Not served.
Learned counsel for the appellant that he has already complied with office objections. And no. When have you served the copy? Has already sent a copy of IA 1 of 23 to by post to pleading applicant on which date? 14 to 23. However, the acknowledgement is not placed on record. Let the application be listed for consideration after proposed respondent is served. Let the read petition.
Sir, you filed application in the month of March. How
You have-
Sir, when you have filed application for impleading, how can you serve in the February? You filed application in the month of March, and you are saying that you have served in the month of February. You do not know anything, just you come. You have not served the application for impleading. Have you served the application for impleading to others, other side? Right.
14th March. No, but don't, I mean, you have to
Sir.
be little more responsible, right? Huh? There's a little more, if my lord would not have pointed out, I mean, you want us to verify each and everything and not to rely on you in any case. This is the message you are trying to give, that don't rely on me. I will say whatever I feel like without verifying the record. We are required to tell you why it is listed. We are required to tell you what have you done. March, you are filing an application, you are saying process fee I have paid in February. How this can?
Sir, now only you serve the application.
Let
Thereafter.
Sir, what can be 14th March, acknowledgement has not been received, list the application for consideration after proposed the respondent is served.
Disposed of matter.
Right.
Filed
Gives
application.
additional evidence.
Additional evidence, you know, has happened in, you know, order dated to.
No,
2019.
sir.
I had filed, you know, affidavit as well as deed, as directed with informal report, along with the application. Which permit me to place on record. He was directed to file an affidavit note by disposing of the. Regarding the terms and conditions of the.
This appeal has already been disposed of. Why have you filed these applications?
I had filed an application.
No orders are required to be passed on IA 1 of 2019 and 1 of 20 as the appeal has already been disposed of by an order dated 2nd of January 2019. But on IA 2 of 20 reasons assigned duly supported, delay of 57 days in filing the appeal is confirmed in the result IA 2 of 22 is allowed. It has been admitted, no? Appeal is admitted for hearing. Office is directed to secure the record.
Records have.
Let the appeal be listed for consideration of IA number so and so on 17th April.
11.
Orders are required to be passed on IA 1 of 23 as the appeal appears to be within limitation. Accordingly, same is disposed of. Heard on the question of admission, appeal is admitted for hearing.
Declaration. Against declaration of
Declaration. Office is directed to secure records of the family court, learned counsel for respondent number 2. Praise warrant is granted. How much time? So how much? That's what we are asking. How much time? In that direction. What direction? Huh? Not to. Learned counsel for respondent praise warrant is granted 2 weeks time to enable him to file objections. In the meanwhile, party shall maintain status quo as it exists today with regard to possession in respect of property. You want to file objection within 1 week. Undertakes to file objection in the objection within 1 week and undertakes not with the execution proceeding till next date of hearing. This is the order, right? Instead of status quo.
Number 12, payment silver, communicated.
Delay. They say that they have paid the this delay of maybe.
Page number 122. Notification dated.
Also, no delay, Mr.
The employee retired from service on 31/10/2005. There is a earlier direction by the honorable court of kindly page number 54.
110, he retired. We will have to hear it. Appeal is admitted for hearing. Yes.
Submission is beyond the cutoff date of 30th June 1939, application for amendment is submitted. So there is a judgment of Honorable Supreme Court on this very issue may not be part of the.
What was the amendment?
form.
Clerical in nature, clarificatory, that may be permissible, but not substantive, right? What is the judgment?
It's a page for 70. None of us will went to consider amendment of form number for permission. With the existence of the learning council, we have gone to the issue and find that the question that arose was whether the beginning could permit an amendment of the cutoff date of the 6th. The last date for filing that under form number. Not in the constitution code. The citation that could that very existence. Also need to clear that. But the same issue that Here also.
We have read, we have read it. What is the amendment sought for by you?
Amendment is instead of survey number 99, survey number 145 was due to an extent of 3 acres.
That's it. That's all.
Yeah, that was included by the land committee. And land committee writing the subject. And is a finding that it is a tenanted land, it is an agricultural land, and the claimant was a continuously in possession of the land and the land occupancy.
You only wanted a change in this thing survey number, correct? That's it. Survey number and extent of land. So initially you had claimed in respect of survey number 99, measuring how much?
Survey number
3.99. And this, then he wanted to substitute it by 145 by.
When you file a petition, only in respect of 145.
So according to you, this amendment is clerical in nature, right? And that's why it is permissible even beyond the cutoff date.
Even the cutoff date, and the land tribunal went into this very subject on this subject alone, and gives a finding after a hearing that he is in possession, he is cultivating as a tenant, and therefore it could be granted. That was the or that it cannot be carried out. It is not.
Of all the application, I have read no objection. I have not even contested the matter before the government. Please respect any member, right to bring all the new survey number within town number 7. I have objected for kindly see the earlier land number order. Just straight away said, yes, there are the tenants respect of survey.
No, the question is, sir, he has filed an application. Thereafter, he, by way of an amendment, he seeks to change the survey number. Would it be in the nature of a arithmetical or clerical error? This proposition of law is well set. Right? If it's a clerical or arithmetical error, it is permissible.
So it is a new survey number which is getting. That one it is not arithmetic.
In the case, it must have been dealt with by some.
Along with the synopsis, produce the judgment together.
That's it. Which judgment?
The division judgment in
Para 6.
nothing possible for the first respondent, however, maintain that the first application, granting the subsequent application made to the prisoner. So that what the first respondent is seeking was only an amendment to the other. We have reviewed that the first respondent are not claiming that he was a tenant of any item of land under which applicant was at liberty to make a first application only before the expiry of the application. Not having done so, is now trying to contest that the first application was not was in the nature of amendment to the first application. It cannot be regarded as an application for can make out an application in form number 7 or an application in nature of an amendment after the expiry of period 3 under section 48(1) of that dating occupancy right in respect of the new item of land not included in the
application. The number shown was survey number 3.99. That is to be deleted and this is to be added.
This division bench says right against you seemingly. Division bench, you have read para 6. Para 6, please read. That squarely answers the question and binds us off division.
This
Please read para 6.
Sita Devi, judgment in Sita Devi's case was considered by the Supreme Court. My lord, there is an earlier judgment before this revocable judgment.
Please read. Para 6, last 5 lines. In the result, we answer.
Result we answer the question set out. First, no person can make an application in form number 7 or an application for the expiry of the period and one of that seeking or getting not included in that within that. Because my respectful submission to this is an application for an amendment is available, and the Supreme Court has gone into this aspect and has said that this is the correction. Because what was thought earlier is in respect of survey number 99, 2 acre 99 cents.
So you are relying on this judge. Supreme Court. Find out this must be reported. And Narayanappa. This is B.S. Ramaswamy. This is judgment. 8th of August 2016. On 16th, it must be reported. You are relying on this. That's it. Thank you.
And the Sita Rai is referred to in this judgment. Paragraph.
It has not been reversed. Sita. Has it been said?
No, that judgment is not taken in appeal. Sita Rai's case is not taken in appeal.
All right.
That is my reference.
Yes. This intra-court appeals. Minutes from an order dated 4th of August 2021 passed by learned single judge, by which great petition prepared by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that late Vasu Acharya filed an application in form number 7 seeking occupancy rights under the provisions of Karnataka Land Reforms Act, which year? 19?
On 26/8/1970.
No. Act.
Amendment Act is one of.
Karnataka Land Reforms Act 1961.
Yes,
One late Vasu Acharya filed an application in form number 7 on
26.
Yes, we have got 26/8/2074. No, 1974. Sorry, 26/8/1974. Under Karnataka Land Reforms Act 1971 for whatever 61 for grant of occupancy rights. First of the land tribunal by an order dated 15/10/1981 granted occupancy rights to late Vasu Acharya and rejected the claim insofar as it pertains to land bearing survey number 145/2 measuring 2.92 acres of Padur village. Full stop. The order passed by the land tribunal was challenged in a writ petition. Full stop. It's single judge of this court by an order dated 24/7/1985 allowed the writ petition and remitted the matter to consider the claim of the respondent in claim of late Vasu Acharya in respect of land bearing survey number 145/2 measuring 2.92 acres. Thereafter late Vasu Acharya filed an application seeking amendment of form number 7 on 16/2/1989. By the proposed amendment, late Vasu Acharya sought to change survey number 145/2 measuring 3.02 acres and to delete the claim for 3.99 cents and amend as 99 cents in survey number 99/4, full stop. The land tribunal by an order dated 22/9/1997 directed the parties to remain present for an inquiry in relation to claim of late Vasu Acharya in respect of land bearing survey number 145/2, paragraph. And what happened? The land tribunal passed an order. Which order?
2011.
The land tribunal paragraph, the land tribunal, you have not mentioned. 27/5.
27, will
Mr. 22/9/97. We are going by, we thought at least on facts, you both will be. There will be. So what, we give us a date of the order. What? Huh? 27. No, not 97. 97. Arey, Mr. It says 22/9/1997 land tribunal directed the parties to remain present for an inquiry. This is not relevant in any case. Delete that sentence. So when was the order passed again by the land tribunal?
2011, NHLE.
The land tribunal by an order dated 27/12/2011 granted occupancy rights to legal heirs of late Vasu Acharya in respect of land bearing survey number 145/2, measuring 3.02 acres. Full stop. The aforesaid order was challenged by respondent number.
4 and 5.
Huh?
Number 4 and 5.
Respondent number 4 and 5.
3 to 5.
3 to 5 in a writ petition. The learned single judge by an order dated 4/8/2021 has allowed the aforesaid writ petition. In the aforesaid factual background, this appeal arises for our consideration. Paragraph. Learned counsel for the appellant submitted that even beyond the cutoff date, even beyond the cutoff date, it is permissible for an applicant to file a petition seeking even beyond cutoff date, that is 30/6/1979. Right? It is permissible for an applicant to file an application seeking amendment of form number 7 in support of aforesaid submission. Reliance has been placed on decision of Supreme Court, Honorable Supreme Court in Sweden. This judgment. On the other hand, learned counsel for respondent number 5 and 6 submits that the issue involved in this appeal is no longer res integra and is squarely covered by a division bench decision of this court in Sita Devi versus Narayan Kamath. Sita Devi versus Narayan. What is the citation, Mr.
ILR 1987, next page.
ILR 1997.
1987, Karnataka.
1987.
Karnataka.
ILR 1987, Karnataka 1779. Paragraph. We have considered this submission made by learned counsel for the parties and have perused the record. Admittedly, the appellants had filed. Admitted the original claimant, namely late Vasu Acharya, had filed an application in form number 7 on 26/8/1974. Thereafter, he filed an application on 16/2/1989, seeking amendment of form number 7 by which not only the survey number but area of the land was thought to be changed. A division bench of this court in Sita Devi Supra has dealt with the aforesaid aspect of the matter and has in para 6 has held as under both para 6. Thus, it is evident that the issue involved in this appeal is fairly covered by a judgment rendered by a bench of this court in Sita Devi Supra. So far as submission, by the reliance placed by learned counsel for the appellant on the decision of Honorable Supreme Court in Narayan D within bracket D by LRs is concerned, comma, in the facts of the aforesaid case, the comma, the aforesaid case is an authority for the proposition that an amendment in the nature of clerical or arithmetical error uh, can be made even after expiry of the prescribed period. That is what is 1619, what is 79. You have written earlier. So and so. Full stop. However, the division bench of this court in so and so Supra, Sita Devi Supra, has held that has expressly held that that amendment in the amendment in form numbers beyond the expiry of the period by including a new item of land cannot be made. Full stop. Paragraph for the aforementioned reasons, we do not find any merit in this appeal. We save bids and is hereby dismissed. It says arithmetical and this thing, and on the facts of that case, it was found that it is not arithmetical. Survey number apart from village also they wanted to change. That Supreme.
Number 14, will be corrected. It is Ravi Shankar. auction procedure. 2012, he participated in the auction. He was confirmed with the favor. He told of the sale certificate. The payment of the sale certificate, as per the Consultancy Act, Rule 96, sale certificate has to be issued to the favor. Letter was pending before the DRT. In an appeal filed by the borrower, the DRT passes an order directing the bank to refund 2 crores 21 lakhs. Any interest or anything, though the bank has enjoyed the money from 2012 and passes an in such circumstances, in the year 2, after 5 years, it is dismissed or the not released an alternative only. Origin of the law is here. I paid 5 lakhs, 21 lakhs in the year 2000. After they being confirmed in my favor, said the value which has been in the manner known to the law, the issuing of the notice and everything, that cannot be set aside in the DRT, and even if it is set aside, as far as actual changes is concerned, he has to be protected. That is the law declared in the case of Desertion, always the name of Christian case and the other case.
That appeal does not lie under section 18. Sadashiv,
He likes you.
Deep Prasad, what judgment, what proposition you are placing?
Case you know to be the similar fashion. For an action is the he has to be. He cannot be his plea, his bid, his sale cannot be ignored and sale certificate issued in his favor. That is the
That
law.
was issued, right? Sale certificate not issued in your favor.
Like it's very clearly says after the receipt of the whole of the amount has to be sale certificate has to be issued.
Yes.
For the option purchase. There will be honored that in terms of the law related to property purchased by a third party after purchasing in compliance with the court order cannot be taken on the basis of the structure or failure of the party to the if option purchaser at bona fide purchase the property. In order to actually the amount that the relevant court will be they emphatic reliance firstly on the judgment related to this court in question years later after 15 years. Our attention was put to the of the patient market theory. In that view of the matter, evidently creation of any third party is not the same is subject to any order of it. In any event, ordinarily a benefit in an option sale is differently. Active order purchasing such property. In the even if such between that the interest of the bona fide purchaser in an action sale is sale. See, not the said decision has been approved by this court in 2006 on the same subject and on the same act. The latter counsel case relying on another judgment rendered by this court in Janta System Interest Tax Recovery Order, wherein the conclusion found in the Association case came to be reiterated. In the above judgment, this court relied upon the decision of the
General Class versus Gurdial Singh, Joginder Singh versus Jaswant Kaur, Adar Nati, Rukmani Ammal versus P.K. Abdullah State also on S.C. State in order to conclude that Janata Exchange case, it is an established principle of law that in a third party option purchaser interest in the option property continues to be protected, notwithstanding that the underlying decrees set aside or otherwise. It is therefore that this court in its ultimate analyzer observed that the law makes a clear distinction who is the bona fide purchaser of the property at an auction sale and a decree holder purchaser at a court auction. Strangers to the decree are afforded because they are not connected with the decree. Unless the protection is extended to them, the court sales do not fetch market value or fair price of the property. So in my case, auction purchaser have paid the market value. Sale has been conducted in accordance with law. So, sale certificates have been issued and to that effect,
Has been done by the Debt Recovery Tribunal by its order dated 27/4/2016.
they have certified the sale proceedings on the ground that notice which has been issued by the bank is dated 10/4/2012 and the draft notice by the bank is dated 5/4/2012. There is a difference of 5 days in the draft notice and the final notice. There was no need for the DRT to consider the draft notice. Actual notice was published in
That what it should have done, that's a different thing, but we are asking you, just sale has been set aside. So you want us to set aside that order passed by DRT in a writ petition and grant you all the reliefs along with sale certificate, etc. Anything else? So this is what it says, that auction is what this protection. Even if it is set aside, the auction property continues to be protected.
Yes.
What, so this is,
Series has found.
no, so what follows from this judgment? What is the proposition? Like,
The proposition in favor, sale in favor of the auction purchaser is confirmed and he was right, it was directed that sale is immediately.
is the ratio? Ratio is not that.
Ratio is your auction purchaser is always protected. An auction purchaser cannot be left on the ground that the decree is set aside. Whether if there was any infirmity,
So is the, like, we want to understand, Mr. Jain, like if it, even if it is set aside, the court should direct issue of sale certificate under 9(6).
two reasons here.
That's what you are.
What I meant.
Even if it is set aside, the court should direct in a petition under Article 226, issue of sale certificate under 9(6), even if DRT has set aside the sale.
For no fraud has been paid by the auction purchaser.
Protected and certificate has to be issued. Has to be issued even if they set aside.
That 23 part of it. Page number 585.
5.
There are 22 units. Since it was nobody's case that Pradhan Prasad Sinha, the highest bidder at the auction conducted on 28/8/2008, had purchased the property in question at a price lesser than the then prevailing market rate, there was no justification whatsoever to set aside the auction purchase made by him on account of explanation of prices thereafter. The High Court is including the vested right of the appellant in the property in question after his action was accepted and confirmed, subjected him to grave injustice by depriving him to property which he had conveniently and repeatedly purchased at a public auction. In our considered view, not only the division bench of the High Court in the manner has to ignore the sound legal and real principle laid down by third party auction purchaser. The High Court also clearly overruled the individual rights vested in the auction purchaser during the pendency of the deed. The High Court also clearly overlooked individual rights vested in the option purchaser by deed.
Yes.
Last sentence.
Yes.
So the bottom of the paragraph, fifth line, more so because the option purchaser was a bona fide purchaser of consideration, having purchased the property in furtherance of a duly publicized public auction. Interference by the High Court even on the ground of equity was clearly unlawful. Why the person will participate?
That's what learned single judge has done. He has not interfered. Lighter vein, Mr. Jain. Yes. Next.
In person participate in the proceeding. Within 15 days, he pays the provision. Immediately thereafter, within.
It's not a question of Mr. Jain, please appreciate it's not a question of depriving of you of your rights. The learned single judge has only told you to file an appeal. By now, you should have filed an appeal and done.
Date of the admission, preliminary that would have been said.
No, supposing if by mistake, I mean, it is entertained, we don't know whether it was admitted. So later on, you want to say that the court cannot relegate.
After 5 years, the matter is posted for week. Here finally, on the ground, that there is an alternative remedy.
Right, yes.
That is not the rule of law that in any case, if there is an alternative remedy.
That's what you are aware, Mr. Jain, that 3-judge bench of Supreme Court in Satyavati Tandon, how it has, what it has said about the High Court.
And the state of HP% municipality has been repeatedly held that wherever there is an occasion arise this problem, to exercise this.
What about Satyavati Tandon? That is debt recovery, special.
Forward, I am not following.
The law will not change merely because you are borrower, guarantor. Law is for everybody, same. If an appeal is, if an appeal is provided, we will have to see the provision to find out whether it permits you to file an appeal or not. It will depend on the, yes, Mr. So what else? So you are saying that we have noted down your contention that auction purchaser is always to be protected. Sale certificate has to be issued to him under Rule 9(6), even if the sale is set aside. Even if the sale is set aside by the debt recovery tribunal, which order is not challenged by anyone, then also it has to be issued. This is your submission. Please appreciate by an order dated 27/4/2016, the sale has been set aside.
It has been set aside.
On whatever ground.
On the ground.
We will have to set aside that order first. We will have to set aside that order first of debt
Mandamus.
recovery tribunal, then grant, then mandamus that they execute
Sales.
sale deed in your favor, sale
Sales.
certificate, whatever. It can't be.
For 9 years, after 9 years, it is based on the order, after depositing whole of the money. If the bank was really honest, just fair and
Why don't you refund this amount?
they are not refunded the amount, they are enjoying it.
Where? Could have transferred the amount. How you are a what, public bank or a private lender or what, enjoying on people's money? What, how? Mister, this law has been enacted to. Why did you not send it? Who prevents you? What demand draft? RTGS, the 1 minute this thing is amount is transferred. What are you talking about? We are not talking of 1910 where demand draft and check has to be issued. You could have, next day you knew his account number. Yeah, but you have to, you don't have any moral right. So only when he only when he enters your bank, only when he this thing pleases your officials, then only they will hand over the demand draft. So this is not
2016 they have answered. 2016 dismissed. They are not challenged. Not challenged. They are good as-
I have to ask him.
Sir, it is in dismissed. DRT dismissed in 2016. What are you doing up to this 2023? No. Writ petition is filed in 2016, but court has directed any direction is there that you should not refund the amount. Then
No,
sir.
the
2000 and whether you are
purchaser
challenging this
is
order.
not under an obligation to please your officers, mister. You are a public sector bank meant for people. Not like this, that he should run around your officers and only when he pleases them, they will hand over a demand draft. Where is that? Any letter? Please produce
You are
that.
not challenging this order also. DRT
You are
order.
not. Then what moral right do you have to retain his money, mister? Have you handed it over to him?
My friend who did this work, I do not want to take it back.
Where has he said? So where did he say? It's like sending a letter at wrong address, some address in Leh where he doesn't reside is not. No. Has he written to you that I will not accept the amount? No. Said means has he written a letter to you? This is your hearsay, right? Your version of the story. Why should we believe it? Oh, this is Mr. Rai. If you are willing to refund of that amount, we will direct that. Refund of amount along with interest. Or you want a decision on merits? Choice is yours.
What is the interest of 18?
Not 18. That we will decide. Interest, you are definitely entitled to, but in accordance with the lending rate. Fixed, you know what is the interest. No.
18% was granted by the other superior.
No. Then why not 25%? Why not 100%? Why not compound interest? Some case Supreme Court may have granted compound interest. Why not apply everything?
Sir, with all this risk only you have participated. You know the consequences. You anticipated
If
litigation.
you want to litigate,
You can't be
we will decide.
preaching.
Why? Should not be. Your money is this thing. This conduct of bank is highly unreasonable. We will give them a certificate. By
File a
writing,
memo. You file a memo saying that I am ready to take back the amount with the interest, whatever court awards.
Court awards.
Consider that and pass
we
on.
will pass an order. Whatever is this thing. They will have to pay back. They can't do like this. This is the public sector bank of our country. See how they are behaving with people's pain. We thought you should advise your client. RTGS. So what is this ego hassle, mister? That until unless he pleases my officers, greases their palm, gives them cut money, I will not hand over the demand draft. This is what it is, Mr. Don't compel us to say anything more. Where is that? No. Where is the proof that he has refused to accept the demand draft? This all, he came, he didn't come, or you turned him away. Who will decide in a writ petition, Mr.? You all know. No, Mr. You, Mr. As a counsel, as an officer of the court, you know what we are saying is more than fair. You know it. Please, don't defend. It's not necessary for you to defend. We are passing an order. You are at liberty, but at least in principle, you should agree that this is what the court is saying is a correct, equitable solution to the problem. If he insists, we will decide on merits if he wants to argue. But this is what is a fair solution to the problem, that you have realized your dues, who have earned interest on that amount, whatever, you are retaining his amount without any justification. Not one day, Mr. You, next date you hand over this thing, demand draft to him. We will decide the question of interest, provided he gives a memo. Right? You don't have any moral right to keep his money. That we will not permit. The memo, Mr. That you are interested in refund of the amount along with the rate of interest, just a minute, along with the interest which may be fixed by this court. If you write this, we will ask them to hand over the draft in this thing, the amount to you. This thing. No.
I would have tell them to me.
No, sir, let your banker bring here.
Bring here.
Demand. He will not come.
What branch? Why? No. The ego.
Otherwise, we'll ask your regional manager.
Ego. Don't. He must have visited in lunch time. No. I am having lunch. Go away. How can you come? I am enjoying my tea. Why should you come? Go back.
This will direct the regional manager present with the check, sir. Will not.
No. We can be really, Mr. We can. No. Mr. Please, we are suggesting you don't indulge in this. It matter to really some other levels which you would not have imagined. We will direct an ombudsman to conduct an inquiry into conduct of your officers and we'll keep this appeal pending. Don't. We are giving you a simple solution, which is an equitable solution. You don't have any moral right to retain his money even for a moment. And like a gentleman, you should refund. You can't argue like this, that otherwise we will take it to some other level. We will direct the banking ombudsman to examine the conducts of your officer and submit a report to us. So we will keep it pending. Let him argue alternative remedy. We are saying. What I mean, the most reasonable thing we are saying, you are opposing even that, Mr. We are, Mr. Sufficiently experienced counsel should have said, my lord, we have no objection in this thing. Refunding the amount, we will do it at the. Then you are not saying that, you are contesting it. That let him come to my bank, let him this thing touch the feet of branch manager, peep at his feet, then only I will. This attitude, not good. That's a simple thing, right? And you, as an officer of the court, you know that this is correct. What we are doing is more than equitable. Right. You should, and interest part, we will decide. You give a memo, Mr. Otherwise, argue on merits. Choice is yours. Learned counsel for the appellant prays for short accommodation to enable him to seek instructions whether the appellant would like to confine his relief claim in this appeal only to refund of the amount along with such interest as may be fixed by this court. This learned counsel for respondent fairly submits that the bank is ready and willing to refund the principal amount, the amount deposited by the appellant, full stop, and the issue of interest may be adjudicated by this court. Actually, don't write this. The amount deposited by him, refund the amount deposited by the appellant. That's all. List on what date? Okay, 20th. List on 20th April 23. Better affidavit. Why you are keeping this pending, right? What has happened? What are the facts? Huh? 55 years or maybe 85 years. That doesn't matter. We are asking you about merits. Why are you taking repeatedly adjournment? There is nothing in your case. That's why. Huh? So then why are you seeking adjournment then repeatedly? You know, see, Mr. 6th March 23, we are just trying to tell you your information. 6th March, weeks time to file a better affidavit. 21st March, 3 weeks further time by way of intelligence to file an better affidavit. So 5 weeks, 1.5, 5 weeks are required. And we are unable to contact him better, but we said all of them. Now, if you say that we are unable to contact the client, nobody will believe. In such an advanced stage of technology, if you say good old days when there were no mobiles, if you would have said that I am trying and this call is in some village, unable to contact, that was an argument in 1980s, not now. Do the needful. That means he is not serious, must have forgotten about the land. Old man must be practicing renunciation, thinking that I have to leave, I have to go, I have to take my onward journey by leaving everything here. So why to contest?
It's covered also. Judgment is covered. Covered. You are purchaser, no?
Yes.
After 15 years, you have filed application.
Purchaser, the grantee has
filed.
Sir.
Grantee has filed. Despite the fact that you have a seemingly good case, you don't want to argue, that means he must have given up the ideas. Why to 75 years of age, why contest? Two opportunities. We don't want to reduce this process into a joke, right? Two opportunities. There has to be an end to somewhere. We will say that a week's time failing which appropriate order. Right. Write his name on 6/3/2023 as well as on 21st of March 2023. Time was granted to learned counsel for the appellant to file better affidavit in support of IA 1 of 21. However, by way of last opportunity, a week's further time is granted to enable him to file a better affidavit, failing which an appropriate order shall be passed on IA 1 of 21. One minute.
One thing is,
Where is the order?
The single judge has recorded some other finding, saying that clear in the sale deed, you have not mentioned that there was construction. This will it is affixed on the property. Gate is also
Extent of property or extent of deviation not mentioned in jobs. Put on the question of admission issue notice. Admission as well as IA 1 of 23 in the meanwhile. Status quo with regard to construction as it is by the appellant will be maintained.
Finally, yeah, I'm
Done. Further reading.
Yes.
Next time, it is that. That is very good.
No, we will adjourn it, not settle. We know that you don't want to argue and you are saying like this. What time we will say so, that you want time to prepare the case, correct? No, how is it that, so this appeal is pending for 7 years? How is it that when it is called, then only you realize that it is going to be settled? You seek time, that is understandable, that I am not ready. See, Mr. The 20th March 23, you sought 2 weeks time. Then, yes, 20th March, if that come up, you had sought time. What did you do? Waiting for the case to be listed and then again seeking adjournment. Learned counsel for the appellant. We'll adjourn at your instance. Learned counsel for the appellant prays for adjournment to legally prepare the case and argue the same. This after ensuing summer vacation. If it is settled, you report settlement, otherwise argue. Right. Mr. Friend, so learned counsel prays for adjournment on the ground that the arguing counsel Mr. K. This after ensuing summer vacation.
Number 20.
Mr. Naik. Memo. No. Now.
Okay. Fair is, to direct the second to prescribe the fee structure in compliance with section 60, Karnataka Professional Education Institute Regulation and Admission and Determination. So, I never challenged the regulation. But there is one document that they produced last year. Yes, yes, yes. That there are 6 seats.
Mr. See, our problem is that if a council argues, we have to hear. So anything out of, you should have told that we, at the instance of a party who has not filed a statement of objection, and at the 11th hour saying something out of the record and trying to help you beyond the case pleaded, obviously, what would be the result? What would be the result, you know, but we have to hear. We cannot ask him that if the council doesn't know that he has not filed a statement of objection, he cannot argue beyond the scope of the petition pleaded. No relief is claimed against him, but we have to hear. We will deal with it suitably in the judgment. You know what fate it will meet.
I'm not banking.
So there's nothing that don't rely on that argument. It's not available to you.
I'm only submitting. What I was.
No, we have not entertained it. We have not entertained. We will not, and we will not entertain it simply because it is not necessary for us to do so. This is not the scope of the petition. Which seat when allotted this thing.
No. What he's producing is germane for this reason. I am banking on it for this reason.
No.
Now we can't submit. I go down to whatever you. Now in that.
So he has not produced. In that case, we will have to hear him first and decide.
But important for both of us, for proper and complete adjudication.
Then you amend the petition. Then you can't be this thing without amending anything, and this we can't entertain. He is producing. Why he is producing, he knows the best. This is beyond the scope of the petition. If he produces, anybody produces, it is our this thing discretion. We have to take a call. There are no pleadings, there is no occasion for us to entertain the memo. We are telling you to be frank in advance. Even if he produces, we will reject it, saying that it is beyond the scope of the petition.
What? Yes, sir.
No. Yes, third.
1 second. What should be hearing for 1 minute?
No, of course. No, this is last date. What do you think we did? Huh?
Lordship allowed me.
With all our patience at our command, we are just interacting. It's not an attempt to prevent you from arguing. Please don't think like that. You can take another rest of the day. No problem. So there's nobody, hardly anybody. They are all sitting to seek adjournment. No problem. You take rest of the day. In any case, we have also forgotten about the case. We also don't know what is it about. Start.
1 month.
But we concluded today. We will not do it again and again. You will have to, if you start, you will have to conclude it today. We will not. No. Why he should produce?
For this reason.
We cannot compel him to produce. Mr. Nayak, are you producing? We don't know. Then, not necessary. Does not arise. This all, we can't prevent him from arguing. No, it's not. Are you producing? Then we will have to give him opportunity to amend the petition. He has given a first prayer. First prayer he has given.
Very important for written
No, you can't bank.
And it is not on matrix. It is within the scope of the pleadings. within the scope of the pleading.
So file an application for production. Then we learned counsel for the petitioner prays for it in order to enable him to file an application seeking direction to which
So
respondent.
this, that, he has already,
Direction to respondent number 5 to produce the document. Produce the document. Let him file. We will not, Mr. It can't be like. Let him file an application. We will issue, then you produce it. This after ensuing summary. Let him file an application, you produce it without an order. Produce it. No, that's why after vacation, we are not troubling you next week. Go to the after vacation. No, he is still saying he needs to be heard. What can be done? We will have to hear him for 1 hour more. We don't have that much of time. We have heard him. So then you volunteer to fight. Mark the presence. Learned senior counsel for respondent number 6 prays for an accommodation to enable him to file what? Enable him to file documents on record. Less tomorrow. After vacation, we can't do like this. We have spent 1.5 hours on this case. We have see the notes. They can't like, and we have not. We can't prepare it in 5 minutes. You have been heard. 1 hour, over an hour. At least you owe a duty to be fair to the court, irrespective of the result of writ petition. Have you not been heard for an hour? Then you are still saying that I should be heard. Hey, what is? We will hear you. We will hear you. Will now this is what it is, right? He is filing. He will file it. You respond. He will file. Learned counsel for the petitioner prays for adjournment in order to enable him to file a response to the documents which may be filed on behalf of learned senior counsel for respondent number 6. This after ensuing. To be frank enough, Mr. Nayak, by lapse of time, we have forgotten everything about it. It will have to be heard afresh. Why to take this exercise with this side of the vacation? Go it. Let him also be freshen up during vacation and come with a new vigor. List after summer. Yeah.
Can I express our conclude?
So, Mr. Nayak, that tells us that perhaps we should not be vocal enough and quietly listen. So this is what
Pass
happens.
orders.
Once we express our
our mind.
mind, then this is what happens. Oh, that's what. That's what. That's what I have always believed. Correct. That's what we expect. At least be fair to the court. This what see how adjournment merely because we said something disclosing our thought process. Twice adjournments have been sought. What can be all?
21. Government advocate.
I appear for the appellant. May I request Millard for tomorrow, Millard. Lots of inconvenience today.
Next week then, it's ready.
Published.
Learned counsel for the appellant prays for adjournment. on the ground. List in the next week.
Publish.
Mr. Mehta, you didn't get it. Left just. Is there? Yes, I got. Here, it has been adjourned. Send it. I will not send it. I will not keep it in that file. Just give it to me. Send it. Yes, I'll send it to Chen. People on. Yes, yes.
This common matter also I have done yesterday. That's at least we'll learn. Here the argument. All cases. Something of that. Never used to speak on the dangerous, but this is a way house.
23. Nagaraj. We need the video conference. Yes.
I think the respect of study of minor work. The appellant or
Yes.
appellants are maternal uncle and aunt.
What happened? No, this thing.
Why is that section?
It has to be heard on merits.
The maternal uncle and aunt of the minor ward. The novelty, the present age of the minor ward was 15 years. By 2008.
1 minute.
The next both items.
Yes.
2008. Minor ward. Years responsibility by 2008. The minor ward. Expired. To order. But
Expired.
expired on 18/5/2008.
Oh, on account of
The husband is a natural father of the natural father of the minor ward. What is the error that the right word is? The right word only considers the legal rights of the husband. This is the paramount interest. However, daily was the fine page number 21. Number 28. The student is support of their contention. I have attempted to do it in. How do you do or how do you see?
where you are where statement where you are reading? Para
Page number 51, paragraph
28.
The student is support of their contention. I have attempted to do it in order to do in order to see. They have imposed the taking care of the main. The response of the main anyway. Because nowhere made any allegation against the they are not what software. They are also not making they are not providing education to the minimum. Especially in the what you do not valid in the law. Right? Is building entire cellular scheme as a molecular. It is only professor in the college in the compared to final. And since from birth of this minor what is he was in custody of the from uncle and grandfather. After the age of university, 8 years, the response by the discussion before the family. The 8 years of the completion of the age of the minor one. Until then,
When?
the application. So,
Waiting for the child to grow up. Yes.
the 8 years would be a application for the and the weddings of the resident. So, what does the appearance of the committed for the people? Child is good. The response is not comfort to the child in minor and immediate document as a father. That point of time is the federal angle and for the given and they are their father.
That you will rectify.
When you have rectified that mistake, the school records. Now school record father name is there.
On verification.
That has been rectified. It has been rectified. No, has it not been rectified? Now you are.
The father, you should be knowing, no? As a father, you should be knowing, no, whether they are rectified or not. In last day to Nagaraj, from last 3 dates of hearing, he has made a statement that it is rectified. The client was present. They are not verified with him whether it is corrected or not.
That shows the concern for
Concern.
your son. The question is in this appeal is fair of the minor boy. So what they did, they inserted their name, this thing. We will decide this question of custody, keeping into account the welfare of the minor boy, which is of paramount consideration. You know the law. Yes. Huh? We didn't say that welfare means what he wants. We will have to decide the question of welfare of the minor boy in the facts of the case. Please tell us how is he better advantaged than being staying with his maternal uncle and aunt? How you will look after the boy. Living alone. What? Because a professor. There is no unnatural father. There is only a father, right?
There is a pleaded anything saying that they are not taking care of the child. Pleading. Except the, I don't accept this hampering of record, whatever you are saying, school record. Any other paragraph to say that they are not taking care of the child. You have pleaded that.
No. It's not a question of your disqualification. You have filed the petition. You have to show. Why did you wait for 8 long years so that the child is taken care of and take away? So the criteria for filing a petition is that the relationship is not so good. Therefore, I should be given custody of my child. That is what. They have forced, that's why custody should be given to you. That's the answer. The law does not say disqualification, qualification, more qualified, more disqualified. That's not what is the, you know it, what is the amount consideration? Welfare of the child. Paramount consideration is welfare of. Tell us why he would be better off if he's with you. You should be grateful. You should be grateful to them. They have brought up your son. You should be grateful. You are calling them criminals. This is the what happens. They have for 8 years. They have looked after your son like their own son, and the net result is they are getting a certificate that they are criminals. Did you file a complaint for an offence under Guardian Watch Act appeal? Can we give a record of finding that forgery committed? They had committed forgery. It was an offence punishable. You should have filed an FIR against them. Not FIR, then what is the complaint? And then don't argue. Then don't argue that. Yes. That is, we have understood that. How many times you will tell us? 3 times you have told us right now. It's not that difficult to understand. How? Now, where from we get it? What, like saying this, I mean, giving a lecture is all right. It's all appeal, material evidence on record, which paragraph, where they have said, how do you prove intention is not good? Is there a finding? All X step is in a writ petition you can give. Read. Where have you proved the intention? Where is the finding by family court that no good intention is not there, therefore custody should be given?
Finding is not on that basis. While allowing the petition, finding is not on the basis of good intention or bad intention. It has gone mainly because you are an. There is no finding that they have not taken care of the child or corrected the document, nothing of that sort.
What have you pleaded? So what they have done? Plead in the petition, where which paragraph you have said, what harm they have caused the child. No, harm. We can't travel beyond the petition, what you have filed before the family. We have understood. That's all. We have understood. We have understood that. How many 4 times you have told us? That's all. They have changed the name and they want to keep the child away from you. That's it. And being a father, you are entitled to custody. Father married again, second wife. Then case. About 8 years.
The child.
Yes.
Bias.
Anything else? Party presence. Argument. Cases reserved for delivery of law.
Uh, I appear for the wife, my lord. And this last time, my lords, on 13/11/2020, this court directed both the parties to file the affidavit as per the law laid down in the case of Rajneesh versus Neha, my lord. There was a direction from this court. And my lord, the husband took a long time and finally filed a affidavit, my lord, without.
It's a case where which you are arguing yesterday, Mr.
Yes, yesterday when we concluded, my lord, Justice Vijay Kumar Patil, my lord, were put a question, my lord, whether since there was no application, formal application by the wife seeking alimony, my lord, whether this petition is maintainable insofar as quantification of permanent alimony, my lord. My lord, there are decided cases on that aspect, my lord. That, my lord asked me where I have claimed that 1 crore. I will be able to show it, my lord. In my affidavit, what in the form of evidence, what I filed before the trial court, my lord, I have quantified 1 crore and I have claimed it as in the event of granting the decree of divorce in favor of the husband, my lord. The court should pay me 1 crore as permanent alimony, lord. Only
Not court. Your husband should pay, not court.
yes, sir.
You are saying court should pay. Why the court will pay? Your husband will pay 1 crore.
I am in the indulgence of this court, my lord, because I've been completely.
You should enjoy the humor. Something is said, everything so seriously. Right? Nobody is hanging you by your neck within next 5 minutes. What so serious about?
No, it's not, my lord. It
So
is.
that's what we said. Why the court will pay? Your husband will pay.
Yes, my lord.
Yes. Okay.
Only I wanted to clarify my lord's query while concluding yesterday's this one, my lord. My lord was inquiring where that 1 crore figure has come, my lord. That is available for my lord's scrutiny at the chief examination filed by the RW1, that is wife, my lord. There, in clause number 33, my lord, there is a specific claim made. The petitioner is liable to pay adequate compensation maintenance to my son till he attains majority, which is moderately estimated by me at rupees 30 lakhs, with reference to present cost of living, cost of education, and cost of basic needs. The petitioner is also liable to pay the permanent alimony of rupees 1 crore to me if the divorce is granted to the petitioner. Because my prayer is not to divorce, my lord. In the event the trial court has to come to a conclusion that my.
So, Mr. You will have to justify your claim of 1 crore.
Yeah, then yes, my lord. Then I will take my lord to the findings of the trial court, my lord. I will take my lord to this page 45 of the impugned order, my lord.
I asked is only correspondent for the son you are not. You know, showing that cross-examination I have stated that respondent pay 1 crore. For son you are not claimed on. 30
30 lakhs for my son. 30 lakhs.
Ah,
And the trial court has granted only 30 lakhs for my son, although it is said RW1.
sir, you must not have reminded the family court about one. That's why it has forgot. Yes.
Yes, sir.
And the permanent alimony for me as a wife is not at all granted by the court, my lord, trial court. I will take my lords to the findings recorded by the trial court, my lord. That the husband has failed to.
She is unable to maintain herself. There has to be an averment. Not in case divorce is granted, award be 5 crores. 1 crore. That automatically you don't become entitled merely because you have made a prayer.
Sir,
Is it your case that he is unable to maintain?
sir, whether you have stated that you are unable to maintain yourself?
Yes, my lord.
And
Yes.
hence you are
Yes, sir.
entitled for 1 crore as a maintenance, or it is automatic one.
Oh, my
Trial
lord.
court, once it is granted decree, you are automatically entitled for some amount.
Oh, my
Maybe
lord.
1 crore, 2 crore.
My claim before in my pleadings before the trial court, my lord, I have
Where you
highlighted,
are stated, you are unable to maintain yourself. Show
I-
from your objections.
apart from, it is not only for the maintenance, my lord, for the compensation,
It's all right, whatever it is alimony, where you have stated, in which para of your statement of counterclaim you have stated that unable to maintain.
my lord, this, in my affidavit filed before the trial court, my lord, I have elicited the entire
Not
scope.
affidavit, pleading, first show from the pleadings.
Yes, my lord. Pleading, sorry.
Counter you have filed.
Yes, counter I have filed.
Where you have stated, which para you have stated that I am unable to maintain myself and my son. Let's grant permanent alimony of this much. I don't have any independent income.
I have not said that I don't have independent income, my lord. I have admittedly, I
Where
have
you have
got,
stated that I am unable to maintain myself. Which para from your pleading? This
Lord.
petition filed for the divorce, no? That you have filed a counter saying that I am entitled for the maintenance. Where you have stated in which para?
this, in para 30, page 13, para 13, my lord. Page 13, the respondent and her son are now left with no homestead, whatsoever at Mangalore. They are now staying in a rented house in Udupi with liability to pay monthly rent of rupees 8,000. The respondent has set up rented house in Udupi as there was nobody to take care of her minor son when she is away from home in connection with her employment at A.B. Shetty Dental College. The respondent is shuttling between Udupi and Deralkatte, Mangalore, ever since she has been prevented from entering into matrimonial house at Mangalore. The respondent was worried about her son's education in Mangalore, who was studying in 4th standard at Mangalore at the time of the respondent was sued, and restraint order was obtained against her by her mother-in-law. Hence, the respondent being left with no alternative and her son was not in a position to shuttle between Udupi and Mangalore for the purpose of studying, she has shifted her son from Mangalore to Udupi for studies and got him joined the school at Udupi. The petitioner is bound to provide a separate shelter at his cost for the respondent and her son with reference to his financial and social status, besides meeting all school expenses, maintenance, and basic needs of the son. In case the petitioner does not wish to provide shelter to the respondent and her son, he has to meet the cost of rent of a suitable, convenient, and reasonable residence for the respondent and her son at Mangalore. The minimum rent for reasonable accommodation in Mangalore is moderately prevailing at rupees 15,000 per month.
That is relating to why you have gone from Mangalore to Udupi and you are paying rent of earlier 8,500. Now you are seeking for 15,000 is reasonable amount. But in addition to that, you are saying that I am working in the A.B. Shetty Dental College. You are not stated that I am unable to maintain myself.
Oh, my lord,
These are the expenses.
oh, my lord, kindly see, my lord. I met with an accident that is admitted, it is there on record. So my earning capacity was reduced and my aged parents were there.
Child, education expense, all that. Where has he quantified that? That is how much expense she has incurred.
One which my lord is to my lord is my lord. The husband has failed to place all the records, what is called for, and all the.
That
Yes.
will infer whatever, if it is required, we will draw the inference. But you please show us from this paragraph, what is the quantification, how much expenses you incur for your child. We'll come to your expenses later. The child you are making, no?
I will draw my this one. I have filed.
Sir, from the pleading, you point out when the child is born, from which date your child is in your custody, how much educational expenses you have incurred, what are the other expenses, and proof for that.
Yeah. Now,
please show for the child, then you will come to your case.
Yes, my lord. I have filed the detailed affidavit, my lord, as per Rajnesh case.
From the pleading, you show us what are the incurred expenditure.
My lord's attention to the detailed submission, which detailed affidavit I filed before this court, and it is available for my lord's scrutiny.
You are saying that you are saying that family court ought to consider and awarded 1 crore as a permanent alimony to you and the child. What was
Yes.
the material before the family court? We wanted to know. What you have placed in the pleading where you have stated that these are the expenditure, 50 lakh is the expenditure for my child. 50
Lord,
lakh for me and future maintenance.
I placed before this court. Kindly see my this affidavit not a file on 10 to
No,
20.
sir, from the objection, you please point out where the quantification you have done.
Only one clarification, my lord. Only one clarification for my lord says that when the trial was going on, my lord, this Rajneesh case was not available for me. Only
No,
when-
that's correct, Mr. Please understand that's correct, but the fact remains, please listen to us first. What my lord is trying to say that you have claimed a one-off maintenance of 1 crore permanent alimony for you, expenses of 30 lakhs for your child, right? Correct?
Yes.
Before the family court, right?
Yes.
So you will have to adduce the evidence before the family court in support of that claim. You cannot say that in this appeal I have filed an affidavit.
My lord,
So if you are telling us your appeal is on this ground that the family court erred in not awarding permanent alimony to me of rupees 1 crore and educational expenses of 30 lakhs to my child, then you will have to tell us this was the material which the family court did not consider, which I had adduced as evidence. You cannot, with reference to affidavit filed in appeal, argue that trial court was wrong in not giving me amount.
my lord.
There
Only-
has to, you have to produce, Mr. You had made a claim before the family court alternatively that in case divorce is granted, I want 1 crore. There has to be some evidence in support of that case. Merely saying 1 crore will not entitle you. So that's what my lord is asking. What is the evidence before the family court to show that you are entitled to 1 crore as permanent alimony and your child is entitled to 30 lakhs?
Correct, my lord is definitely correct, my lord.
That's what we told you in the beginning, the council, that you are not realizing that it is in your interest to file a petition under section 25, lead evidence and prove income, do what, but you are arguing, so we will decide it.
My lord,
Tell us, what is the evidence before the family court?
I will draw only one finding of the trial court, my lord. This
Evidence before the family court in support of the claim for maintenance of 1 crore and 30 lakhs.
during the trial, before the trial court, my lord, the trial court directed him to produce the details of his income. And during the trial, my lord, he transferred the property in favor of his mother during the trial, just to defeat my interest, my lord. From his name, he transfers the property in favor of his mother.
Transferring the property does not entitle you to 1 crore and 30 lakhs.
That property is more than 6 crore today, my lord. That property is more than 6 crore today. And the petitioner.
Mister, you should have claimed 60 crores. Why did you claim 1 crore?
Lord,
You are sufficiently senior person and you have sufficient experience. We are only, it's a very simple question to you. What is the evidence in support of claim of 1 crore and 30 lakhs? Please point out before the family court, and how that has been ignored by family court. That's how, please tell us, simple.
Plus, in exhibit R23, my lords, I have furnished all the bank details, exhibit R23, before the trial court. And based on this, the trial court holds that, my lord, drawing inference under section 106 of the Evidence Act, he has failed to do it deliberately. So therefore, he is not providing the details. Trial court records a finding and drawing adverse inference under section 106 of the Evidence Act, that he has failed to do it. And same thing happened before this court also, my lord. So there are 2 affidavits are filed before this court. When I pointed out that he has not furnished all the details, my lord, before this court also in the appeal, then this court makes a specific direction against the husband, my lord, to file a better affidavit. Even until today, it is not filed. And the cause list disclosed, my lord, that he has not filed despite the direction from this court.
No. So despite the direction from the court, if a party does not file a document, what is the legal position?
The adverse inference can be drawn, my lord.
We do.
Yes, my lord.
whatever, he knows the law also, other side also knows the law that despite direction, he is not filing.
Even today, even as on today, they are not.
So if they don't file an affidavit, that doesn't mean that we will award 50 crores.
No, I am not. See, I am not avaricious. I am not.
Even if they don't file an affidavit, your claim is for 1 crore and 30 lakhs. We are justified in asking you what is the material to show that you are entitled to 1 crore and 30 lakhs. Simple. You are telling he has not filed affidavit, he has not done that. Let him not do it.
During the trial, because he failed to produce his the information within his command, my lord, the trial court records that therefore he draws adverse conduct. And I have provided all the input to the trial judge, my lord, that where all his practice. He is most famous dental surgeon in Bangalore, my lord.
We can't. I'm not from this state. I do not know his client. I can't. And I have not gone ever for my tooth extraction to Mangalore. That I can tell you. And neither my brother judge has gone. So we do not know he is a famous dentist, infamous dentist.
Definitely not that
person, a very noble person. We don't.
No, it is where all he is practicing. It has come.
Sir, once again, we will make a request to you. Please point out, read from the evidence.
What is the
justification for your claim?
1 crore 30 lakhs. What basis?
Yes, yes.
Education expenses, which are.
Yes, it is that. This in my my lord, this in the pleading, my lord, this in the especially in the matrimonial matter, my lord, if any is in the pleading, that is countered in the court we have filed. So therefore, it is a consistent interpretation that in a matrimonial list, my lord, so this anything placed in the welfare of the couples, in the welfare of the spouse, according to me, I am the aggrieved with my minor child. So my grievance, most of that not able to disclose at the relevant points of time, my lord. Now, when in the appellate stage, when we are able to handle this, my lord, I may have some deficiency in pointing out the specific pleading, because at the relevant point of time, there may be intention to revive the marriage or ensure reconnection because my minor child was there. So therefore, any deficiency in the pleading itself will not hold me that I have not pleaded there, my lord. But when
You are muted, sir.
So you muted.
Please unmute, sir.
sorry, my lord. So therefore, my
Now, whether you are receiving any maintenance from any of the proceedings?
only 7,500 from a DV Act, my lord. Only for my son, not for me. Not for me. And there was a direction, even by this court, my lord, the DV Act, the trial court directed me to provide an alternate accommodation for me and my son. It did not provide. And that was agitated before the lower first appellate court, division court. And that has upheld, my lord. And against which it came before this court, the learned single judge, my lord, dismissed it, upholding the trial court direction to provide me alternate accommodation. Even as on today, for last 7 years, it is not produced, my lord. I have been leading my life on my own. No compensation is granted to me. And the trial court also, my lord, while recording the compensation, my lord, says that it is not only maintenance, it is a compensation for all the tortures that I have undergone in my marital life with him.
Sir,
Which provision compensation can be granted?
Huh? Alimony, my lord. I'm sorry, alimony.
Compensation, Mr. That we were wondering under which provision,
Because
under public law doctrine or what under compensation you are entitled to. And government advocate is telling us that they have not caused any harm to you. Therefore, they are not liable to pay compensation to you. He was telling us that why should we pay compensation to the applicant? We have not harmed her in any way.
Lord, this
Which proceedings order is made for the accommodation?
in DV Act, the learned single judge of this court, my lord, has dismissed that and directed the husband to provide alternate accommodation, my lord. That is in
Got two expenses incurred by him. In the
this the revision petition number 1041 of 2016. Order of the court is dated 9/7/2019, my lord. I've already filed a memo on 18/12/2021, my lord.
All right, you want us to take, you would like to take to the evidence part where you have evidence to show that you have incurred expenses for your son or towards you.
Yeah, I will show
Sir,
you.
you stated that?
Yeah, I can able to link it, my lord. What is this? It starts from para 6, page 6, my lord. Initially, the petitioner has,
Where you are ready?
it starts para 6 in page 6, my lord.
About
Para 8, para 8, my lord. Para 8.
the judgment.
No, my pleading, that is evidence filed before the trial court.
affidavit.
Evidence at page 6, para 7, 8, my lord.
RW1.
RW1. I am RW1, my lord. Initially, the petitioner has encouraged me to join MDS after a gap of 7 years from completion of my BDS and also promised that he will pay the fees of.
One minute, please wait. We are trying to find out. Which MC number
Yes.
is it?
Yes. He has also filed appeal, sir. He has filed appeal saying that the like is more.
From here I read. Shall I read, my lord? Para 6. Page 6, para 8, my lord.
1 second. Getting.
He did not pay. After I know that I only paid in this one. It is for this institution also. Both of them got many petition and signing of MD first. Later, both of this had prepared a special teaching program. I was doing all of it.
The page begins with para 6, but I draw my lord's attention to para 8, my lord. Initially, the petitioner has encouraged me to join the MDS after a gap of 7 years from completion of my.
1 second, please. This is not what. Para?
Para 8, my lord, but it is in page 6, internal page 6.
No, it is page 2.
I am reading from the RW1, my lord.
It's para number 17, then Roman 6.
No, para number 8, my lord, in page 6, Roman para 6. Roman.
That is in para 17, Roman.
Yes, my lord. Sorry, my lord. 17, 6, yeah. 17, 8, I read now. Initially, the petitioner has encouraged me to join the MDS after a gap of 7 years from completion of my BDS and also promised that he will pay the fees of MDS course to the institution. At the time of joining, the petitioner has paid me fee of rupees 4.6 lakhs for the first year MDS course. Later on, he has insisted me to avail the education loan from the bank, telling that the fee amount already paid should be returned back to the person whom he allegedly borrowed from. As a result, I have agreed to borrow the loan on the promise of the petitioner that he will pay the loan installments regularly. Accordingly, petitioner himself has arranged the loan of 7.5 lakhs from Centenary Branch, Mangalore. I have signed the loan documents as a borrower, and the petitioner stood as co-borrower, and Dr. Hitendra Puranik stood as a guarantor. The amount of 4.6 lakhs was paid by the petitioner out of 7.5 lakhs towards the fee of my 1-year MDS course. During the second year, MDS also, the petitioner has forced me to avail the personal loan, and he has arranged the loan facility with SBI Bank, SL Tower, Mangalore, to the tune of 7.5 lakhs. I have signed the loan document.
You are muted, sir. Sir, muted.
Oh, yes.
It's pertaining to loan, no, two bank, Canara Bank and SBI.
First, he promised me, and in my name he took personal loan, and he made me to remit, my lord. So,
Other than this,
next, para 9, my lord. It is essentially important to note that though the petitioner promised to clear the loan dues, he has backed out and deliberately failed to pay the loan dues till today. Though he is capable of repaying the loan dues, I was always remitting the petitioner for a payment of loan dues regarding regularly immediately after 1 year from the date of completion of my MDS course, that is somewhere in the month of June 2013. But the petitioner, instead of bothering to pay the loan dues as per his promise, he has started insisting me to bring the money from my father as dowry for the reasons quoted by him, that since his marriage with me was love marriage, he did not get any dowry, and therefore I have to bring the money to clear the entire loan dues from my father as dowry. The mother of
loan he has promised, but he has not understood. Next paragraph.
the
Paragraph to say relating to expenses.
The mother of the petitioner has supported her son in the said regard, and she was also pressurizing me to bring money from my father as dowry. I have resisted politely the said demand of petitioner and reminded him of that I joined MDS after 7 years of BDS, only on his insistence leaving my job, and also adding to that an important fact that he had collected my entire salary for 7 years, during which the period I was working for Enepoya Dental College after completion of my BDS. The petitioner, being highly enraged on hearing the said, my humble reply has hit me mercilessly, for which the mother of the petitioner has not only supported but also asked him to throw me out of matrimonial house. The petitioner physically dragged me out of the house, and the mother of the petitioner was yelling at me with filthy words. The similar incidents had taken place on several occasions whenever I asked money for my son with petitioner and cleared the loan dues. I was subjected to physical, verbal, and emotional economic abuse and threats, and by the petitioner, for which his mother has given all sorts of support to him, besides encouraging him to step up his cruelty upon me. After 1 year from the date of completion of my MDS, we both started getting calls from both the banks regarding the repayment of the loan dues. Thereafter, the bank started sending written notices to both of us and the guarantor once the loan became overdue and NPA. At that time also, I have repeatedly requested the petitioner to clear the loan dues. Whenever I have requested him to clear the loan dues, I used to get beastly beating and filthy abuses from the petitioner.
I understood, sir.
Yes,
That was understood that loan is borrowed on the assurance that he will pay, but he has not paid.
started, my lord. So therefore, my lord, this I wanted to lead a very honest life with the.
He has said that it is for your benefit you have taken to do the MD. Who has repaid?
She was a guarantee.
Guarantee receiver.
Criminal case was filed against her.
Who has paid the loan? Mr. Kamath?
My lord, what happened, my lord? This partly I have paid through when I started earning loan, my lord. And the bank, my lord, initiated proceedings against his sisters also. What happened, my lord? To avoid any, because they're all well settled doctors, practicing doctors in Mangalore, my lord. With a view to prevent them, they paid and they have initiated a recovery suit against me. They have initiated.
paid.
Yes.
So therefore, it's not that you have paid the amount.
Yes, my lord. And I am
Taken loan for doing MD and his sister has paid it.
Paid
And
it.
they have filed now suit against you for recovery.
They have filed a recovery suit against me.
That's correct.
Yes, my lord.
That you contest.
Yes, my lord.
Yes.
It's not, this
Anything, sir?
submission that I have repaid the loan is not correct.
Anything?
So here, what my submission before my lord says that throughout I had a very, very torturous life, my lord, right from beginning. So this the marriage itself was misconceived, and because of my endurance and tolerance, my lord, because at home my aged parents were there. So because of my mother is a cancer patient, and it will have different repercussion on the parents, on my parents. So therefore, my lord, my endurance was misused. And the various attitude at home, my lord, has impacted my son, who was very young. And he is a karate master, my lord. With all his disturbances, I have ensured that he is going to become a good citizen of this country. So therefore, I have given him the best education, despite my own commitment before the colleges, my lord, because I am a teacher. I have to educate my students.
What is the age of the son? What he is doing?
Just during the pendency of this petition, my lord, just attained majority, just last year, last 6 months back, my lord.
What he is doing, sir? Now?
Now he is 18, my lord.
What he is doing?
He's studying, my lord.
What study?
Yeah,
Courses?
he completed 10th standard, 12th standard, my lord. But 12th standard, because of various these disturbances, my lord, his education was little affected. Because he
He has not joined any college?
he is yet to go for colleges, my lord. He failed in 12th standard. He failed in 12th standard. He could not complete it. So therefore, he took a re-exam, my lord. And not failed, but he got a lesser mark. So with a view to develop his career, my lord, he took re-exam.
That's all, sir?
This in the same this one, my lord. Just one this one I'll take my lords to para 15 in the same this one, my lord. It starts when I did not have any income of my own. So in the same this one, para 15 in that 17. Page 10, my lord, page 10. Internal page 10. What my lord were saying, the same internal page 10. Clause 15, my lord. When I did not have any income of my own, it was my father used to give money to me to meet the expenses towards basic needs of myself and my son. The petitioner has neglected me and my son deliberately in every respect to force me to bring money from my father. The school fee and other expenses of my son also met by me alone, so far with the help of my father. So I have brought everywhere, my lord. And this court also took note of this fact, my lord, while giving direction in the learned single judge while disposing of criminal division petition, what I cited now, my lord. So this observed it. So he has to provide alternate accommodation and give various this one. I have already produced on 18/12/2021, my lord, with a memo. I have filed a memo before this court that is available for my lord's scrutiny in my memo dated 18/12/2021. The learned single, while disposing of the criminal division filed by the husband, my lord, has given a warning also. Please provide him the accommodation, and despite that, he has not provided, my lord.
Yes, sir. Sir.
This submission, my lord, in this type of place, my lord, where matrimonial justice is there, where as a lone woman, I have suffered severely in the hands of the husband, my lord. And he has, how he has conducted himself, my lord, in transferring the property in favor of his mother during the trial stage itself. And this inspiring his mother to get a order of injunction against me from the trial court, my lord, seeking prohibiting my entry into my own matrimonial home. So the mother of the husband, my lord, took a prohibitory order from the trial court because it was in the name of her husband, that is father of the husband. She got a this prohibitory order when I had been to my parents' place. So then by the time I returned back, the prohibitory orders were there against me, ex parte. So I was prevented to enter my own matrimonial home. Belongings were there. So this type of tortures were also given, my lord. Kindly this appreciate, my lord. At that relevant point of time, I have not committed any errors, my lord. Even today, my lord, even after this grant of this decree by the trial court, my lord, I have preserved the sanctity of my marriage because I believe in only one marriage. And the husband, my lord, he got immediately remarried. Immediately after the appeal period, my lord, very next day, he got remarried. But I have preserved the sanctity. I have not remarried. I have not violated any of my moral duty towards this, and I have ensured that my son is not completely disturbed with all this conduct, torturous conduct of his father. That is my husband. So therefore, my lord, I pray before this honorable court to take note of. As my lord observed, my lord, there may be deficiency in my pleadings, but my nowhere I have committed any lapse of my individuality. And even now, my lord, although I have been teaching in the law, dental college, my lord, with my determination, I have done my PhD, my lord, beyond MDS, and with a view to impart education to the students. I have conducted that despite my own so much complications at home. So therefore, I pray before this court to consider the matrimonial justice for me because I am severely aggrieved. Only one point can I bring to my lord's notice, my lord, the trial court's observation with regard to permanent alimony, only that part, my lord. Because the cruelty, desertion, I will not touch it at all because I have given up. I will take, my lord, only to the findings of the trial court, only in so far as this present my prayer is before this court. How the trial court has dealt, only that part I will take. It is only 2 paras, my lord.
Yes.
It starts from para 30 and page 42 of the impugned order, my lord. Yeah. In my appeal number, this 8526, impugned order, impugned judgment of the trial court. Para 30, my lord. Only 2 paras I will read, my lord. RW1, that is me, a wife, my lord, has claimed permanent alimony of ₹1 crore from PW1 in case court comes to the conclusion that PW1 is entitled to get divorced. RW1 has deposed that her minor son was previously studying in Canada School, Mangalore. Because of all these incidents happened, nobody was there to look after him, and she does not have any residential house at Mangalore. As her mother-in-law, by filing a suit, obtained an injunction order against her from entering into her house. She has shifted to Udupi and residing in a rented house by taking the house on lease. She has produced rent agreement as per Exhibit R3, R31 and R32 to that effect that she is paying rent of ₹8,000 and additional 500 towards maintenance and 40,000 towards deposit. As she is working at FB Shetty Dental College, she used to attend her duties by traveling from Udupi to Mangalore by up and down. She has deposed that she has met with a two-wheeler accident and was admitted to hospital as inpatient, and it is her father has provided treatment to her. To substantiate it, she has produced Exhibit R30, the hospital records. Even she has undergone plastic surgery also. Just prior to leaving the matrimonial home at Mangalore, she has written a letter to the director, Pradna Santwana Women Helpline, Kankanadi, Mangalore, and detailed out her feelings, which also shows that everything was not well at the relevant point of time and circumstances under which she was compelled to leave the matrimonial home. And because of the injunction order obtained by filing the suit by PW2, she has become houseless. Now her son is studying 6th standard in Sailas International School, Udupi. She has produced number of school fee paid receipts. That means she is burdened with the educational expenses of her son, transportation charges, food, clothing, medicines, etc. Days to come in future, the education expenses will be more. RW1 has deposed that PW1 is working as a reader in Yenepoya Dental College and earning more than rupees 50,000 per month. And it is her say that he is running a dental clinic in the first floor of Manjushri Complex, Dongarkiri, Mangalore. And from the said practice, he is earning more than rupees 1 lakh per month. She has deposed that he is also visiting to various clinics and hospitals in and around Mangalore and earning more than rupees 1 lakh apart from his salary. Thus, he is earning more than rupees 2,50,000 per month. She claims that in addition to permanent alimony, the educational expenses of the child for the present and future, she has estimated rupees 30 lakhs. In the cross-examination, RW1 has stated that now she is working as a senior lecturer in Dr. M.V. Shetty Dental College, Derlakatte, Mangalore, and drawing salary of rupees 35,000 per month, and denied the suggestion that she is getting UGC scale and drawing 80,000 per month. PW1 has tried to prove that she is getting more salary what she has deposed. No doubt, she is doing job. Certainly, she is earning rupees 35,000 per month. R1 cannot say that he is not liable to pay permanent alimony to her, because under Section 25 of the Hindu Marriage Act, at the time of drawing decree for divorce, it is necessary to determine the permanent alimony payable by PW1 to RW1, either on monthly, yearly basis, or in one lump sum. It is not the maintenance, but it is compensation by way of damages payable by him to RW1 for pain and mental agonies suffered by her because of the severance of marital status by means of divorce decree passed by the court. PW1 has deposed that since 20th March 2014, he is residing separately in a rented house at door number so-and-so. Even PW3 has deposed that PW1 is residing in his house, and for some time he has stayed in a rented house at Mannagudde, Mangalore. RW1 has denied this said fact. The fact that he is only son to his parent. His father was a famous criminal lawyer and recently during the pendency of this case died. PW2 is residing in a big house situated near PVS Circle, Mangalore. It has come in the evidence of PW1 used to visit his mother. He can't say that he does not have any house property, even though for some purpose he got settled the property in his name since 2003 in the name of his mother under Exhibit R2. In the cross-examination, he admits that previously he was using I-10 car, now possessed Eco Sports Ford car, and he has purchased the said car during 2015 itself. Though he is working as a reader in Yenepoya Medical College, he is also running a clinic at Dongarkeri. He admits that subsequent to the temporary injunction order passed in a suit filed by his mother, he did not pay anything to his son, such as cloth, books, money, etc. In page number 39 of the cross-examination, PW1 has stated that he was visiting Yenepoya Hospital, 2 clinics at Kumble, Badiadka, Kasaragod, Kulai, and Mangalore. Kasaragod is about 55 kilometers away from Mangalore, Badiadka, so-and-so kilometer away from Mangalore, and Kulai, so-and-so from. The say of RW1 is that by visiting such clinics, he used to practice in dental surgery and earning. As visiting all the above said places, RW1 used to call the people of those centers and makes false propaganda against him. In Kumble, Dr. Deepika told him about the said fact. In Kasaragod, one lady assistant revealed the assistant in his clinic. RW1 has denied the said fact. At least he could have examined any of the independent witnesses to prove that because of making such false propaganda against him, he stopped visiting the above said centers. Therefore, one thing is clear, that out of the personal knowledge that he has been practicing by visiting the above said centers and had sufficient earnings, RW1 has deposed about his earning. Once he admits that he used to visit the above said places in connection with the practice as a visiting surgeon, mere say that he has stopped, it cannot be appreciated. Therefore, it can be inferred that even till today, he is visiting those centers and had earnings. The very fact that he has not disclosed about his true earnings shows that he has not come up with his true earnings and suppressed the material facts. Though he has stated that he is prepared to produce IT return submitted by him for the last 4 years, but did not chosen to produce the same, especially when there is a claim by the wife in a divorce case regarding maintenance or alimony, etc. The facts within the knowledge of PW1 about his earnings should have been divulged as required under Section 106 of the Evidence Act. He withheld the material evidence and suppressed the same. His contention that she herself abandoned his society and deserted him cannot be appreciated, even though this court has come to the conclusion that on the ground of cruelty there is no chance of reunion and divorce is the solution. It does not mean that he should be exonerated from paying permanent alimony to her and maintenance to the minor son. On 29/3/2014, as usual, she went to her parental house. She did not have any mind to desert him or put an end to the marital tie. But PW1 and his mother hatched up a plan in OS number 411 of 2014 and obtained an injunction order preventing her from entering into the family house. And a week prior to it, according to him, he started residing in a rented house at Managuda, and he has never tried to convene panchayat nor issued any legal notice to call her back. Therefore, whole gamut of the case echoes against PW1 that his intention was to keep her away from this matrimonial sphere. Therefore, certainly he is liable to pay permanent alimony to RW1 for the pain and mental agony she has suffered because of passing of divorce decree severing the marital status. She has been shouldered with the responsibility of providing good education to the child, and his future requirement is more when he is grew up. As she does not have any house to stay in Mangalore, she is working in Dr. A.B. Shetty Dental College, and she has made it clear that the salary which she is getting is not sufficient. RW1 has stated that to get 2-bedroom house at Mangalore on rental basis, she has to incur rupees 15,000 per month, and she is expected to lead moderate good life, even though she had some earnings, but she should be adequately compensated by way of damages by PW1, as this court has inclined to pass decree of divorce severing the marital status. Under Section 25 of the Hindu Marriage Act, court need to take into consideration the social status, the conduct of the parties, the way of living, the spouse, and such other aspect while determining the quantum of alimony, as has been ruled in the decision of Honorable Apex Court in Civil Appeal number so and so in the case of Vinny Paramveer Parmar versus Parmar. He is senior dental surgeon working as a reader in NFOI Hospital, Mangalore since 2002. I had put up sufficient length of service and also clinic at Dongarkeri, Mangalore, and he has been visiting various centers in and around Mangalore, as well as other places at Kasaragod district in Kerala state. Therefore, it can be said that he is having income more than rupees 2 lakh per month. If PW1 is directed to pay permanent alimony of rupees 30 lakh to RW1, that is just and reasonable. Though PW1 has not claimed custody or visitation right of the minor son Atreya, under Section 26 of the Hindu Marriage Act, custody of the minor son shall continue with the guardian mother, and in the ends of justice, reasonable visitation rights is given. This is the finding, my lord. And kindly see, my lord, observe, my lord, he has never made any claim to take care of his son. He has not come out with this one because he is his son. What an impact he would have created on the son, minor son. How the welfare would have been damaged, my lord. It was the trial court has taken that fact also into cognizance, my lord. So while granting 30,000 only 30 lakhs only for the RW1, my lord, this one is prayers before this court, my lord, with the vast the experience of this court, my lord. Anything that is clear, I want to lead my life with the complete away from litigation aspect, my lord, and take care of my son because he is already severely damaged. I want to focus on him as well as my professional career, man. So if with the vast knowledge of this court, my lord, in considering my minor son, and I am leading my life with my son, I have no property at all. Everything I have already this equitable relief may also be contemplated to save my commitment to preserve the dignity of this marriage, man. Yes.
Continue at 245. 245, not. Please come at 245.
Please, you come, we'll take up your case. First, we will take up your case only.
Your case only. We are taking.
When it reaches, you make a mention.
Yes.
The other side will not be there, they will come and complain.
Both the sides
Consider.
are there.
We consider the request only if they are there or at the when it is called.
Yes.
No, other side is there. Same.
We have covered everything, no?
Yes.
45. 45. Mr. V.S. Nayak, Learned Counsel for the applicant. Oh. Yes. Right, madam. Mr. V.S. Nayak, Counsel for the applicant, submits that the appellant has expired when more than 2 years back. In this connection, attention of this court has been invited to a memo filed today. Line below, the aforesaid memo is taken on record. The result, line below in the result, it is further submitted. After you say it is further submitted that legal representatives of deceased appellant are not interested prosecuting this appeal. Line below. The appeal is therefore dismissed as admitted. Right. Written. Yes. Yeah, after conclusion of argument, you are here. We thought that you should have been here earlier. Mister, find out why it is happening. Other side, you can't hear. So therefore, you have come to hear. Okay. Yes.
Yes.
Yes. One thing, broadly speaking, Mr. You cannot run away from, I don't think you will dispute this proposition that you are under a moral obligation to maintain your son. Right? He is your son, you have to take care of. And all along, you have not taken care of. Reasonable, she must have incurred some expense, whatever expense. Bearing this in mind, you argue. In 14, but he was born when? Okay, 10 years. So till 2014, you have taken care of the son. From now, what he is only now he has to pursue higher education, right? Whatever. That's why we asked what is he doing. He didn't answer. He only said he is expert in what martial arts, some karate training. That will not help in life. Karate will not help. Huh? You have to be black belt and something like that. No. What is he doing? Nothing.
He wanted to pursue legal education. But what? Then fees and all, who will pay that? Salary is 35 lakh rupees, approximately 2 lakh rupees you earn. From the date of injunction, you are not paid anything. That is evidence you are admitted in. Injunction, what mother has got injunction, not allowed. Staying in rented premises. All education expenses up to PVC is she has taken, except 12,000 rupees. Strictly, they are not given the backups and all. But fact is that he is your son and you have not paid anything.
Yes, you have to take care.
Fine, so he has also filed a appeal saying that 30 lakh is higher one.
Crore is not granted, only 30 lakhs for so what? 30 lakhs she would easily incur, Mr. Like for expenses if he is admitted to even your this course, BTS course.
Cannot be paid.
In lakhs. What is the amount which is sought to be recovered in that suit?
It's the sister and you also. Yeah. Wife. Bank has filed. Is it Canara Bank? I'll suit against you. Age also you have to see. Age.
You have stated your affidavit 95,000.
It's 69. You joined rapid, no? What are your income tax returns you are not? 21. 20?
Income. Latest.
Income tax return is at what page? Page. Affidavit dated 25 to 83. Page number? Private practice. Private practice, you have clinic, no? Okay. Where you are ready?
That's what he told. Fine, fine. He told us that he has a clinic but no patients. COVID. Due to COVID, naturally, his explanation seems to be correct. COVID, who will go to a dentist? Thereafter, he says that these cases have affected his reputation like anything, and nobody now wants to come.
Yes. Okay.
Don't argue that, otherwise dependency will increase.
I told this to video conferencing also, you told this, he transferred. We remember.
Yes. Okay. Hold on. We have one, next place, like, come back. So, please show it, go back to the. See.
That is not the case. We are only deciding quantum of maintenance.
So,
When was that? When was that cross examination done? Very end. After COVID happened.
COVID happened in 2020. At that time, we asked, and, even he considered it possible. And no, is really
Sports. Echo sports. Not sports.
So, let's see. So, what do you was appeal. I was is my condition. That is a virtual condition. Despite this direction from this one. Yes.
Yes, that's it. Retreat what para 25.
This para 25 to management. It's
Give it. Ah, 20. If I put it.
51.
Tell us the paragraph, we can find out.
Above para 22.
Huh? Yeah, exactly.
25 permanent alimony and maintenance.
Ah,
52 to para 24. 25 provides rent a permanent.
Yes.
that is not the case.
It is for
He
variance.
he did not argue that you are not chaste, therefore not entitled to maintenance. Not his case. Arguing something which is not set up against you, that's not his case. That you are having an affair, therefore not entitled, you are not chaste. Nobody is saying. Why should you argue this? None of the case. Not the case. You are referring to guidelines. You have read only section 25. That could have been read in Hindu from the act also. Ah.
At least we did. The document evidences with respect to expenditures.
Criteria.
It's not.
Not saying no income. He has filed the income tax return and saying that I am earning 95,000 rupees. Not saying. We thought that you have concluded.
Sir, it is reply,
Like going on.
reply to his submission.
Oh, that's why he has come. No, you are not reading para 81 last 3 lines. They are also important.
Sorry. It's come.
Wife is able to maintain herself. So this is what we were repeatedly asking. Where is the pleading that this I am unable to make both ends meet in this my salary and I want additional amount of say whatever lakhs or crores. No pleading. Saying in the prayer clause 5 crores not sufficient. Not judicial. What Supreme Court says in number of judges. You have read it. He has to determine whether income of the wife is sufficient to enable her to maintain herself. The source of income, the income of both the parties is similar. And he is not running away from his responsibility to maintain his son. That he can't run away. We will not permit him to run away. He is not saying that he is unable, no source of income, able-bodied person without any job. He is not saying that. Please understand. He has filed the income tax return. He is saying that I am a dental surgeon employed as a professor, whatever, reader. He is saying so. Why are you reading that he is unable to maintain? He is not saying that I am unable to maintain myself. Not saying. No, I mean, what? Please read the judgment in the context, right? He's not saying you are reading that able-bodied person, if he has sufficient qualification, he cannot say that I will not maintain. He's not saying claiming, right? You are in the position of a claimant. You have to establish repeatedly 4 times we have asked you, you didn't tell us anything. Neither any evidence, no pleading that you want this, not able to maintain yourself with this income. Never. What can we say? Fine. We have already argued this merely because appellant has joined through online. You cannot go on arguing. We understand why you have come here and why you are arguing. We see her online. She is there watching the proceeding. Therefore, you have come from office and you are arguing. All correct. No, good. You should come here. Good. You are welcome here. Yes. 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 Who have to bring the material on record? I mean, you did not bring.
Is the reason in the beginning we have said that cross-examination witness box is required for all these things. You are not agreed for that. Yeah, whatever affidavit he has filed, we have to accept it. In the absence of any material placed by you.
It is not your case. You find an affidavit that does not represent his true income and is guilty of suppression. Is it your case? No. No, don't drawing attention means we can't do anything. There is no presumption that he is dishonest and concealing his income. There is no presumption in law like this. Critical see. Clinic doesn't mean Mr. Don't. That was 2014 cross exam. So at least I mean in this argument you are getting a compliment from your wife. Very superior surgeon. Huh? Yes. So argument for yes, without for delivery. Another wife.
What I have said, dependency is increased now.
Huh?
He will bring her now income tax returns.
Yes, correct.
Yes, I mark that. Yes, 91.
Yes, each other. Yes. Right. This very clear. Yes.
Heading is there, so where wife is working. Done. Into that. That's another one. Some both are entitled because he is meeting. She has maintained the child. People are popular. Education and
Sitting since morning just to seek an accommodation. Party jointly pray for adjournment. Just after ensuing celebration. Explain the delay. When was the land granted? 1944. When was the sale? 677. 77 is 365 days. The sale can't be on all 365 days. There has to be a date, right? 3/6/1977. One minute. When did you file the petition under the Act? 2010. What date? 2/11. Date you don't know. When was the application filed? You must know the date, right? After how many years, madam? 33. What was held by the this thing? Deputy Assistant Commissioner? 2/11/2012. Appeal was dismissed. What is the date of that order? Which respondent? When? Madam, 33 years delay, please explain. That doesn't explain. Madam, this only 79 and 80. This writ petition was dismissed in 80. You filed an application in 2010, 30 years, still 30 years. In a suit, whatever, if you have, this proceeding under this act cannot be, this thing held. 33. No. This is all decided by Supreme Court day in and day out. We are passing on. No, this all covered. Not it.
Already sufficient adjournment. Order sheet only.
Last date also you sought an adjournment.
Yes to that also.
Nothing, not, it is fair on our part to pass an order. No, madam, we are more than convinced it is fair on our part. Yes, sir. Listen to us. We have the power to pass an order. It is not fair on your part to seek adjournment, but it is perfectly fair on our part to follow the law laid down by Supreme Court and to pass order in a writ petition which is pending for 5 years. Twice. No, it's not, madam. We are not in conversation with each other. Please appreciate. You cannot address the court by please, etc. We are not an informal. We are High Court judge. This is a High Court. I am not even a distinct person. I am a person occupying this chair. This is High Court. You cannot take please this thing. You do it like you can't. We are not talking to each other in a corridor. And nothing. We agree. No. We have.
Order sheet you please kindly see. Don't make such a request. I know every day he comes and waits and you have said submission that senior is not well, somebody is not well.
31st March 23, we would have adjourned if there was some point in your case. We are following, please, no, sorry. Either you appear or you don't interrupt. Don't interrupt. We are following the Supreme Court decision, which we have followed in several other cases. Fine. Nothing. What's your name? You want your this thing, or should we say none for the appellate? No, madam. Don't. This is not a negotiation and bargaining. We are not doing bargaining.
You should be fair, madam. Don't come to the court if you are making this kind of submission. Don't come. See the order. Order sheet, please see. At your instances, we have adjourned the matter. We read and come and make a basis.
Not agree to keep on interrupting. We are passing an order. You cannot prevent us.
Please take your seat.
You want your presence to be recorded or not? None for the appellant. None for the appellant. Mark the presence. Learned counsel for respondent. Don't interrupt, madam. This amounts to. Please help Mr. Micus. She wants her presence. We can record her senior's presence also. If she wants, we can record her senior's presence also. All this is covered by Supreme Court decision. You tell her. You know that in each and every case we have said covered, madam.
This is not the first time I am seeking adjournment. Not the same ground.
Twice he has sought adjournment. This gentleman has not said anything. He has waited patiently. What is this? You get your seniors. Ask her to get her seniors' presence marked. That we are willing to do. Oh. Auction sale held on. Who purchased? Recording to this intra-court appeal emanates from an order dated 20th November 2018, passed by learned single by which the petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to paragraph. Facts giving rise to filing of this appeal briefly stated are that one Muni Gangappa, one Muni Gangappa, one Lechri Muni Gangappa had purchased the land measuring 4 acres of survey number 13, survey number 22, situated at Jannasandra village, Uttarahalli, Hubli, Bangalore, South Taluk, in an auction sale which was held on 18,944. So the aforesaid land was sold. The aforesaid land was sold to respondent number 1 to deceased respondent number 1 on 3/6/1977 paragraph. After a period of 33 years, 6/8/2010, legal representatives of deceased Muniappa, named Muni Gangappa, namely the appellants, filed a petition under the provisions of Act, under the provisions of PTCL Act. PTCL Act, right? The best thing is to, right, under the provisions of Karnataka, worked under the chambers of Chief Justice, he doesn't know PTCL Act. Is it possible? Even Shakuntala Madam would tell what is PTCL Act. So the thing is to feign ignorance that I don't know it. Perhaps we could also do it, that we do not know about the law and adjourn all case. We can't do it. Right. Surprising, no? Yes. You haven't typed this act ever? Deliberately ask you to take dictation. No, Lordship, I'm under the
Provisions of.
under the provisions of Karnataka, right? Right is why leave it to
Karnataka, scheduled castes and scheduled tribes. Prevention of.
this bracket prohibition of transfer.
Very nice.
At least right now, why should you leave it? Credit Laws Act 1978. The said application was allowed by the Assistant Commissioner by an order dated 2/11/2012, and the land was direct and the land was restored in favor of the LRs of deceased Muni Gangappa. Full stop. The deceased respondent number 1 referred an appeal before the Deputy Commissioner, which was dismissed by an order dated 3/8/2017. Paragraph. The orders passed by the Commissioner and Deputy Commissioner were challenged by the legal representatives of respondent number 1 in a writ petition. The writ petition, the aforesaid writ petition has been allowed by an order dated 20th November 2018 by the learned single judge. The aforesaid factual background is appeal rises for our consideration. Paragraph. We have considered the rival submissions made on both sides and have perused the record. This paragraph. After this paragraph. Right, paragraph. In now paragraph, in the instant case, the application for restoration was filed after an inordinate delay of 33 years. Full stop. Thus, the proceeding initiated in the act suffers from delay and latches for which no explanation has been offered. Full stop. Full stop. For yet another reason. Full stop. For another reason, comma, the provisions of the act have no application to the obtaining factual metrics of the case, as the land in question was purchased in an auction on 18/9/44 by the predecessor of the appellants, namely Muni Gangappa. Full stop. Paragraph. For the aforementioned reasons, we do not find any ground to differ with the view taken by learned single judge. In the result, appeal fails and is hereby dismissed. What is your senior's name, madam? What is his name? Mr. DC? Mr. DC Deepak, along with, what's your name? Latashri, learned counsel for the appellant. And Mr. Shankar Shetty.
AGA.
And write her name also. Learned additional government advocate. Why? It has been abandoned. It has been abandoned. So after summer vacation, right? You will take a decision after summer vacation. Huh? Learned counsel for parties jointly pray for adjournment. List after summer vacation. Vacation then. No point in repeating for the next. Just to make indication then learned counsel for the so and so. Learned counsel corresponded praise for adjournment on the ground that arguing counsel is not well. List after summer vacation. So, when the file
Mediation.
mediation
17.
17 matter after 5 years mediation.
Wait.
When will you appear? Learned counsel for the parties. Along with parties present, learned counsel for the parties further submit, learned counsel for the parties submit. That there is a possibility of amicable settlement of this between them, and they are ready and willing to appear before the final mediation session on such day as may be fixed by this court. In view of opposite submission, parties are directed to appear before the 17th,
Records may not go.
20th April, with 21st April. On 21st April at 3:30 p.m.
Shastri. Shastri. Mr. Shastri. Huh?
Counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same. This after ensuing summary vacation. Sometime. Huh? Counsel for the appellant prays for adjournment on the ground that arguing counsel is not available. List after ensuing summer vacation.
Vacation, sir. Vacation.
He's praying for. You are looking at us. He is praying for adjournment.
After
You are
vacation.
praying-
After. Yes.
So after vacation, that's what my lord is telling you.
I thought you were making some submission. For that reason, I asked.
Tell him it's adjourned after vacation.
Yes.
35 APF for respond, my lord. Regarding divorce refused, against that the husband has come in appeal. I'm sorry, I couldn't hear what my tenant friend said.
Mike.
ಕೇಳ್ತಾ ಇಲ್ಲ.
It's on. You speak from this side. No, it's on probably.
It's on. My lord, as per the appellants, the.
Yes, Mr. Sharma, now you
No,
can
here.
hear.
Yes, my lord. My lord, as per the appellants, the respondent, the appellant. Separately, past 33 or 34 years, it's giving you a signal as well. Relax. There's no need to panic. We are hearing you. There is a for the past 34 years, my lord. There is a for the past 34 years. And then so the main grounds for divorce was Desertion advising by the appellant, the husband. And we have, my lord, the respondent. Respondent in the evidence is clearly mentioned that they're not staying together past 10 years. Addition is one made by the appellant for disbursement.
Let husband.
Husband
On what grounds he has filed?
on
the ground of cruelty and desertion. What are the cruelty of pleaded?
My lord, there is that she has left me and she left me went away. From the past 33 years, and I have taken care of the kids. And I am the only one. And then living me.
She has left 35 years, 33 years. It is sufficient to prove the desertion. What section says, whether you have pleaded that? You have act direct. Will you? What section you have filed petition? 1B now you are saying. Is it that? One B. Got that? One B. Slowly.
The petitioner for a continuous period of not less than 2 years, immediately preceding the presentation of the petition.
So, prior to filing of 2 years, she should have been deserted when you have filed the petition. And where you have stated that she has deserted prior to the 2 years of the filing of the petition. When you have filed the petition, what date?
My lord, the petition is filed in the year 2012, my lord.
12.
Yes, my lord.
January to December, we have to take date or
My
not?
lord, he deserted me in the year 1989, my lord.
You should can't say like this. You have to say from the pleading.
Yes, my lord. From the pleading,
Date of the petition. When you have filed the petition.
27/12.
Sir, let him argue, sir.
20th July 2012.
Yes, sir. We have records. I have seen that. Let him argue. I have
Sorry,
seen that.
sorry.
Yes, sir.
on 4/7/2012, my lord. MC petition filed.
No. 20th July 2012.
Yes, my lord.
In which paragraph you have stated that she has left on so and so date? You have records. You have a petition.
Further submitted that the respondent has rejected the petition in the year 1989, and for about 23 years, both petitioner and respondent are residing separately from each other. And the respondent has rejected the petitioner only with an intention to put an end to the marital relationship. And all the efforts made by the petitioner is within vain, as a result of which, by considering the development of the marriage petition.
What efforts you have made to bring her back? You have sent notice immediately from 1989.
My lord, there's no letter of any records, my lord. But like really going and meeting her. That's it, my lord. So even she has accepted that she's not staying with the appellant, my lord. Even the evidence given by her in the during the cross examination, my lord.
Please read the explanation here. Section 13. You got that?
Yes, my lord.
Explanation.
Yes, my lord.
After this Roman. Explanation.
In the subsection, the expression desertion means the decision of the petitioner by the other party, marriage without reasonable cause and without content or against the
Consent.
wish, consent and or against the wish of such party, and includes the willful neglect of the petitioner by the way of party to the marriage and its grammatic variations and conjugate expression shall be construed accordingly.
From 1989, 2012, you have filed the petition. In between what you have done, whether you have sent any legal notice asking her to rejoin, or have you filed a petition for restitution of conjugal rights?
There's no such record.
Section 23 also you please read.
In any proceedings under this act, whether the defendant or not, if the court is satisfied that any of the grounds for granting relief exist and the petitioner, except in the case specified in subclause as A, subclause B, or subclause C, clauses of section 5, not in any way taking advantage of his or her own wrong or disability of the person. The ground of the petition is ground specified in the clause of subsection 1 of section 13. The petitioner has not any manner been accessory to or convinced to or condone that the act or the act complained of, or where the ground of the petition is cruelty. The petitioner has not in any manner condoned the cruelty, and when a divorce is sought on the ground of mutual consent, such consent has not been obtained by force, fraud, or undue influence. The main reason for me to file the MC petition was that in the year 2012, my lord, there was son's marriage taking place, my lord.
Clause clause D. 3(1)D.
Yes, my lord. 23 clause 1D, there has not been any unnecessary or improper delay in instituting the proceedings.
Satisfied that there is no unnecessary or improper delay. 2099 she left you and you filed the petition what?
89.
89, yes, my lord.
2012 yes filed.
Yes, my lord. My lord, in 2012, there was a marriage of my second son going on, my lord. At that time, the respondent, she intervened the marriage, my lord, and then she created ruckus like, yes, my lord.
You can't tell the stories.
I know, my lord, like, the main reason is that they both were living separately, happily together, happily, my lord. But once there was a disturbance, the reason for me to file the divorce only arose when she came to this my second son marriage and created ruckus, my lord, over there. If she had not done that, like, the main reason why she had done that, because the marriage was still pending. The marriage between, it was not dissolved, my lord. That was the main reason why she came to the marriage and she created a ruckus, my lord. And that is the main reason why I have filed the for divorce under decision, my lord. My lord, and even she has agreed that in her evidence that they're not staying together from past 10 years. My lord, like, even if the we said appeal is dismissed, my lord, but they're not going to stay together also, my lord, the husband and wife. My main humble request is that amicably the matter is being settled also, my lords. Like, in the sense like,
File a memo.
my lords, like,
Settlement if it is set.
if the respondent advocate wants to, because they're not stay together, my lords. Even if it is dismissed also, they're not going to again stay together also, my lords.
That is not the ground under section 30.
And
If the appeal is dismissed, they are not.
No, my lord, that's why.
Their court decree should be granted.
No, my lord, like,
We can grant the degree only on the grounds mentioned. in
yes, my lord. Well,
You cannot grant
My lord, sir.
Even if it is dismissed, they are
Yes, my
not
lord.
going to stay together.
My lord, there's a condition taken by the lower court. My lord, sir, in their, in the judgment.
Either you don't understand or you are too smart. These are the only two confusions.
No, my lord, no,
We
my lord.
made you read 23.
Yes, my lord, yes, my lord.
23 1D.
Yes, my lord.
So my lord has asked a query to you that you are not answering. Your wife left you in 1989.
89, yes, my lord.
So then 2012 you have filed the petition. What have you done for 11 and how many years?
23 years.
20.
So 23 years.
Years. What? Why it should not be dismissed? If you are comfortable living separately for 23 years, why do you want a divorce now?
My lord,
We
like,
have to live separately.
my lord, in 2012, like, she had not intervened in the marriage and created ruckus. My lord, this only happened because there's a marriage pending, my lord, sir.
And whatever comes in your mind.
23D.
Yes, my
You have
lord.
read 23 1D.
Yes, my
Either what have you understood?
Yes, my lord.
Please tell us.
Yes,
You haven't brought the book. We have given you the
Yes,
book.
ma'am.
You read. We made you read 23 1D. You tell us, please, what have you understood? 1D again, and please tell us what have you understood.
yes, my lord.
Read.
There has not been any unnecessary or improper delay in instituting the proceedings.
The court has to be satisfied
Yes, my lord.
that there is no unreasonable
Yes, my lord.
and improper delay. What is the explanation? Meeting ruckus in 2011 is fine, but what did you do from 89 till creation of ruckus? That's the question. At 23 years, you were able to manage without her. Continue to live separately. We have to. Yes, no, correct. That's most important.
My lord, I'm paying in alimony of rupees 20,000, my lord, like every month, my lord, maintenance to her.
That
Yes, my lord.
even if we grant a decree of divorce.
Yes, my lord, yes, my lord. No, but while we can even, yes, my lord, sir. Permanent alimony must be sorted out all.
It comes out.
No, my lord, yes, my lord.
You are
My apology.
Huh?
Yeah.
2020 match like it's like.
Anything, whatever you feel like, right?
No, my lord.
And it's not even a moot. You feel that it's not even a moot court competition, right?
No, my
Not
lord.
even a moot court. You are arguing before High Court, saying anything what you feel. It can be sorted out. Who will sort out? We are not going to sort out. We are here to decide your appeal in accordance with law.
Yes, my lord.
To the correct legal position.
Yes, my
Don't
lord.
say anything, whatever you feel.
No, my lord. The only reason that I kept it for the 23 years is that because there was no living separately and there was no disturbance from or
So Mr. Then 23 1D, this entitles you to any relief. Fine.
no, my lord. No.
Fine. You are not offering any explanation. Fine. Yes. Yes.
My lord, the trial court, my lord, has taken a decision that that there is no desertion by the appellant. The appellant has not been deserted. The decision taken by the trial court and the trial court has erred, my lord, saying that the only contention is taken by the appellant and not by the respondent. My lord, in the cross-examination, she admits it's been referred in judgment also, my lord. It is a judgment passed by the trial court. Page number 32, my lord. Has been passed by the trial court, my lord, sir. They have considered that he had married third wife and living with her, and hence since 10 years they are residing separately. Wherein the respondent also taken a consideration that is staying separately from the respondent for the past 10 years, my lord. And she has also not made any efforts for the to join back with the appellant.
What is the difference between desertion and living separately? Whether law contemplates living separately, degree of What is the ground? 13(1) on which you filed the petition?
Which matter?
What is it? The section. Separately does not entitle you to degree of private. Desertion.
Yes, my lord.
What is desertion?
My lords, living separately is that he had two kids, my lords, and she has left and gone, my lords. That amounts desertion only, my lords.
Living separately amounts to desertion. Right. We will record your submission. That living separately according to you amounts to desertion. Correct. We'll deal with this submission in our judgment. Supreme Court has said what is desertion. Section itself says what is desertion. When one spouse leaves the matrimonial home with no intention to return, that is called desertion. Living separately doesn't mean parties may live separately under mutual consent also. You know, it's a distinct, different concept. We are not your professors.
No,
in
my
law,
lord.
right?
My apologies.
There is not
My
an
lord,
LLB
sir,
class
sir.
going on in Hindu law where we will make you teach what should be this thing, what is section 30. It's not a class going on. This is High Court. You are arguing an appeal. You don't understand, fine. We will not. Our object is not to convince you. Right? You argue whatever you say. Yes.
We can continue.
No, no. Don't learn this dirty trick. I said in the beginning, I want adjournment, we would have given you adjournment. We compel you.
No, my lord.
Huh?
No, my lord.
You argued, right?
Yes, ma'am.
Don't learn this dirty trick of
No, my lord, sir.
coming to know what the judges are saying, then seeking adjournment convenient. We will not adjourn the case now. Go ahead. We have given our book to you. Then you should at least take the court to at least argue the case properly, right? Anything else?
But when the respondent has herself mentioned that she's living separately for the past 10 years, and then it has been more than 17 years, my lord, and she has not made any efforts to come to return to the matrimonial home, or she has stayed with herself only, my lord, and the appellant has raised two kids, my lord, on by himself, and he has done all the him during the necessary time, my lord, by researching him, and based on that, and during those time periods, the appellant has gone through rigorous study cruelty, my lord, by not being part of it, and he has raised two kids on himself by himself, and my lord, the respondent only intention is to harass my client, my lord.
So, anything else? Yes, Mr. Sharma.
Yes, my lord. This matter, my lord, it's actually a case of the age your lordship may kindly see the two people. One is they are quite aged people, and they have children and grandchildren, and one is a professor in and another is a engineer.
Yes.
And this marriage was in 74.
No
And
cost.
he
Remarriage,
wants,
right?
may make one submission.
Huh? Ruled out, no?
My lord, what has happened is this, actually, your lordship kindly see, he married during the subsistence of this marriage, he married a girl in Mandya, she died, and allegations were made regarding the death. Now again, she is living with another Vijayalakshmi and he has purchased properties in the name of Vijayalakshmi. Vijayalakshmi showing in the sale deed as husband is this man. And after she came to know that she objected. That is why after long time, now he wants a divorce to get a regularization of the marriage of that Vijayalakshmi. That is the crux of the whole thing. And it is even in the sale deed, produced in the sale deed as exhibit, it is shown that Vijayalakshmi is the wife of this Balan. That kind of arrangement he has made. 20 acres of land he has purchased in her name. And now he wants to regularize that by removing this.
In this appeal, we are not going into how many acres he has purchased.
No, what I am saying is the reason behind is this, the delay is because of that. Now he wants that.
Mark, what's your name? Counsel for the appellant, Mr. Y.K. Sharma. Case is reserved for.
And he can't take advantage of his own fault. Now he wants to this way. And she does not want to be called as a divorced woman at this age with these senior children and grandchildren.
Next time you will read 23D1, right?
Give us that.
23D1. Give that book. That's important. It belongs to the court, not to us. To the court.
He wants to argue further, my lord?
There is Shama. There to argue. With your experience. What? Yes.
May I know your lordship pronounced it order? Or
Reserved, sir. Reserved.
reserved. Very well, man. Only
My
one
lord.
document I wanted to point out is that exhibit D22 where the sale deed is taken in the name of this present wife or the next wife.
We are afraid that it's not relevant.
Very well.
There are ground for desertion or cruelty is made out. Sale deed is not important.
Solid.
Purchasing a property in the name of somebody else other than your wife does not amount to cruelty. Which law says that?
Not somebody else. He has shown as his wife. His wife. That is the exhibit. Very well. That is the exhibit. That's why I pointed out. Very well, my lord. It's all right. It's not a case. He can't take his own fault as an advantage and do it.
My lord, can I make a request, renew my request for accommodation in serial number 40, my lord? I appear for the appellant. Yesterday, of course, my lord, yesterday my learned friend objected. I have taken instructions, my lord. The stay order granted is stay of further proceedings in the labor court, and the matter is posted to 26th of June. So no harm is going to be caused, my lord, if this matter is taken up with the first week of
26th June. Before that, we will give a date.
That's right, my lord. First week of June.
Labor court
Senior
matter.
counsel is paying for a judgment. He wants it. Your application. What you have to say? But yesterday you created problem for us, and that's why he is waiting. And today you are saying no problem. See, Mr. Raghavan, our predicament.
I know, my lord.
So she's saying no problem. So she could have said yesterday also, no problem.
Possibly, my lord, my learned friend took instructions.
Shouldn't say no problem. You should say I have no objection to adjournment.
That's right. That's right. Correct.
No problem. Just now we told that young boy, right, who was arguing like T20 match. Consider it even to be a moot court, let alone high court. To have appeared before moot court. How did you argue? You told the judges sitting there, no problem. 40. Learned senior counsel for Mr. K.M. Raghavan, learned senior counsel for the appellant, praise for adjournment after the ensuing subrogation.
first week of June, may I request, my lord?
Yes, in first week of June.
Grateful. I'm very grateful, my lord. Sorry to trouble your lordships, my lord. I apologize.
Kejira, Kejira.
Oh, Mr. Kejira, sorry. Yes.
Grateful.
What? Huh?
Pastor, come tomorrow.
It will be repeated tomorrow. First. Which one?
Tomorrow we'll consider that.
Tomorrow we can see. Who appears against? We have no problem in adjourning in his presence, not be tomorrow. He may say like in this case.
No, yesterday they have opposed. Today they have come and said that I have no objection. That happens. Both of you are there. You please make a mention.
Make a mention. We have no problem. We'll adjourn. 36.
Both of you are there. Same place.
Other side. You should tell them no that we will make a mention at 450 out of turn even if case is not. Next week. What? Why next week after vacation? Which case?
7006. Serial number
36. Learned counsel to parties to only pray for adjournment. Just after ensuing summary. Who is for this?
On record, advocate is not here. Hospitalized, huh? At least for
No other respondent is there. We'll adjourn it tomorrow, please.
please.
No problem.
Please.
Let the other side.
Please.
Adjourn it. Don't. Will be repeated tomorrow, Mr. All cases.